Let's see.
I'm going to start scheduling this case.
The meeting is being live streamed. Yes, got it.
What happened? I mean, when you put the phone in my hand and jump in, you probably need to come kind of sit down over here and hold the phone. They won't.
Oh my God.
You're joining out of clinic. I was nervous. I actually love it. My weight went down, lost it better. Great. I lost 40 pounds today. It's 20% off any trip if you join mentally weight loss.
Good morning.
Good morning.
Hi, my name is Hector Serta. I believe I have a court at 8:30, I believe it is.
Yes, 8:30.
I was also trying to get in contact with my lawyer. He was not answering his phone either.
We'll be with you in a moment.
Oh, that's somebody.
Waking up at the hospital after an accident is terrifying. Luckily, my husband is there and called me. Right now.
Can I try calling him again and dial back in?
I'll be right there.
Go ahead.
1821 is the current time. 33 is your temp. We got east at 9. That push your chill down into the fall. So we have that winter feel. Yeah, in part, it's no way to show.
Carnita's not going to be here today.
Right. Want me to call?
Are you guys ready for Scott?
Okay.
Yours isn't until 8:30. They've got another one going.
Usually waiting for the video until they come on screen. The way this company works, the one before you see
Not paying attention.
yeah, so this is somebody else. I'm seeing a lot of people. Don't worry about it.
Good. Is coming.
No, they still got it.
Okay. Just trying to- She's looking at the schedule, Judge. I can't reach Karen, but Mr. Wilson.
Oh,
You guys got your passes?
See the lawyer. She starts at 8:30.
Okay. Scott? When I hear the start talking, I'll shut the door.
All right.
You might wanna come forward so they can see your face a little bit. There you go.
Sir, please remove that off your head. Thank you.
Are you still going with somebody else? Okay, we're having.
Good morning, Judge.
Morning.
I'm going to be stepping in today for APA drain,
Okay.
and I'll be in person as soon as we're done with these PCs.
Pronounce your last name for me.
It's Movsesian.
So it's gonna be okay. Is it
Good morning.
this guy that they have?
How are you?
Good. So yours will probably be next.
You okay?
I'm good. How are you?
Did I? Okay. I don't have my head. I thought you were upset.
After tomorrow.
Oh, after tomorrow.
Yes, ma'am.
Okay. Well,
That's how fast it goes.
My hair.
Yeah.
The first couple is gonna get the next one. Like, where? ECC, so they always get me.
That's the slowest part. Exams.
Oh.
Oh, no.
here we go again. In about 3 days, you'll be burning it back now.
Yeah. Yeah. We have anything coming down right now? Oh, yeah.
I mean. Want to?
I need two. One big one.
Some people. I'm gonna have to print you.
What's your, CSI?
Hold on. Oh, this one.
Beth? Beth? COF and I.
Oh, okay.
CSR 309.
Can't see.
Join.
No, this is probably somebody new on the desk and all that other stuff. What day was it, Saturday? All right, let me let you go on and Judge King's court. All right,
Mhm. Harrison. Mhm.
Okay, we're gonna get started. First up is Mr. Cripps. Mr. Cripps, are you there? Mr. Cripps going once. Mr. Cripps going twice.
I'm here, Judge.
Good morning, sir. You here on Harper?
Yes, Judge, I'm here on Harper.
Okay. Good.
This is case number 2257675, State of Michigan versus defendant 1. Okay, yeah, Deontay Harper is being charged with count 1, homicide, 1st degree. Count 2, 4th degree arson. Count 3, tampering with evidence. Count 4, police officer fleeing 3rd degree. And he's a habitual offender, 3rd offense notice. Today's date and time is scheduled for a competency hearing. Appearances, please.
Appearances for the record. Do I have an ADA here on Harper? Oh, well, Mr. Cripps, you know who the APA is on this case?
I'm trying to remember. It did switch. Might be Jonathan Hitz. I'll have
I'm
to
on
con-
devious Weathers, not Harper. I can try to figure out who's on Harper though.
Okay. Thank you, Jonathan.
Yeah, I'm gonna come back to you, Mr. Cripps.
Okay, Judge.
I think. Sorry, Judge. I was going to say Mr. Cripps is also on devious Weathers, but either way, Judge.
Mr. Kenny. Mr. Kenny going once. Mr. Kenny going twice. You're here on Weathers as well, Mr. Cripps?
Yes, Your Honor, I am.
Okay, we'll call Weathers.
Just like he just heard from the First Lady, he's been very focused.
This is case number 2259294. The people of the state of Michigan versus first name is Debeius, last name Weathers. He's being charged with homicide, 1st degree premeditated. Count 3, weapons carrying concealed. And count 5, weapons firearm. Today's date and time is scheduled for a probable cause hearing.
Appearances for the record, please.
Yes, Jonathan Hitz appearing on behalf of the people. May it please this honorable court, P85288.
Good morning, Judge David Cripps, P34972, appearing on behalf of Mr. Weathers.
Correction. That's a competency hearing.
Right.
And Judge, just for the record, he's also charged with kidnapping and fleeing and eluding 3rd degree counts 2 and 4.
All right, do I have Mr. Weathers here?
I can waive his appearance, Your Honor. We're waiting on a report from my independent expert. I know she's seen him, And I think she's pretty near completion of her report. So I anticipate I'll be getting the report within the next 2 to 3 weeks.
All right. I will adjourn the competency hearing to March 20th at 8:30.
It's fine for the defense.
And that's fine with the people, Judge. I would just note there has been a delay in this case, and the victim's family is calling me about it. To the extent that it isn't ready by March 20th, I would just be asking for a show cause order for the expert.
Well, Mr. Hitz, I'd ask you to relax a little bit. We have to wait a long time for the forensic center many times. I will emphasize to my doctor, I'll call her today, the urgency of putting this high priority, and I'll get it to you as quickly as possible. I apologize for any delay.
I understand. I'm not asking for it now. Just on the.
Thank you.
Mr. Hitz, do you know who the prosecutor is on Harvard?
I believe it's James Kehoe. What's the first name of that defendant? Is that Deontay?
Yes.
Yes.
Yeah.
It is Mr. Kehoe. Thank you for fresh in my memory.
And I'll let APA Kehoe know that everyone's waiting for him.
Thank you. I appreciate that. Robert Kenny, are you here? Mr. Kenny going once, Mr. Kenny going twice. Mr. Evelyn, good morning.
I'm gonna sign it. I really do.
Good morning, Your Honor. Always good to see you.
What can I do for you?
I have Johnny Hardiman for PCC. It's an adjourned PCC.
Hardiman, okay.
This is case number 2255822. The people of the state of Michigan versus Johnny Hartman. Count 1, assault with a dangerous weapon. Count 2, domestic violence, habitual offender, second offense notice. Today's date and time is scheduled for a probable cause.
Appearances for the record, please.
Good morning, Your Honor. Sonam of CCN on behalf of the people, P83923.
Good morning, Your Honor. May it please the court, I am Gerald Evelyn, P29182, if I must, on behalf of Johnny Hardiman, Your Honor. This is an adjourned PCC. We would like a preliminary exam date, Your Honor, and it is a felonious assault involving a water bottle, allegedly.
Are you waiving your client's appearance?
He should be appearing by Zoom, Your Honor. He is here.
Are you here, Mr. Hardiman?
Yes, Your Honor.
Tell me your name for the record.
Johnny Hardiman.
All right, the court will continue to plead not guilty and set this matter for preliminary examination. How is March 10th at 11:45?
I just have one moment, Your Honor. I believe that is a fine day. March 10th, 11:25, that's fine, Your Honor.
11:45.
I'm sorry, 11:45. That will.
Okay. As long as we continue.
Thank you, Judge. Good to see you.
Good to see you as well. Ms. Quick, good morning.
Good morning, Judge. I'm here with Mr. Terry Taylor. Mr. Taylor is also present via Zoom.
This is case number 2355631. The people of the state of Michigan versus Terry Taylor. Count 1, home invasion. Count 2, assault or assault with a battery. Habitual offender, fourth offense notice. Today's date and time is scheduled for a probable cause hearing.
Appearances for the record, please.
Terry Taylor.
Ms. Lovisian.
Yes, Judge. I'm sorry. I didn't see this.
I can't hear you.
I said, I'm sorry, Judge. I didn't see this one on my docket, but Sonam of CCN on behalf of the people, P83923.
Good morning, Your Honor. Neighborhood Defender Service by Cheryl Quick, P83973, on behalf of Mr. Terry Taylor, who is present and who has identified himself.
Okay, what's your pleasure, Ms. Quick?
Your Honor, we'd like to set this for a preliminary examination.
All right, the court will continue to set this matter for preliminary examination. How is March 10th at 9:45?
May I have one moment. I have multiple hearings across the street on the 10th. Is the court available on the 9th?
It's my homicide day.
Okay.
March 8th at 9:45.
Yes, that's fine. And Your Honor, we'd also request to address Mr. Taylor's tether. We did submit a written motion over the weekend. I received the documentation as to his employment. But essentially, Mr. Taylor is currently on house arrest with the GPS tether, and he's asking to be able to leave his home to go to work. He works at the Fast Splash Car Wash on, I believe it's the Plymouth Road and Beach Daily location. I spoke with the district manager and at Fast Splash, and I put his contact information in the motion. He confirmed with me that Mr. Taylor does work there. He's the manager of that location. Mr. Taylor submitted to me like a check summary from his last payment from Fast Splash. I did try to reach out to their like corporate HR manager and was unable to reach her. I left a message.
People, you have any objection?
Judge, I'm not as familiar with this because I don't have the file, unfortunately. However, I also didn't receive the motion over the weekend, but if the request is just for him to be able to leave the home to go to work, we do not have an objection to that, as long as everything is verified based on whatever motion that was submitted to the court.
So Ms. Quick, send over a proposed order to that effect, but make sure it indicates that as long as the employment is verified.
Yes, the motion should be, or the order should be in the court's possession. And the motion indicates that I personally spoke with Mr. Anton and put his contact information in, as well as the hours that Mr. Terry works.
You send it.
Pardon me?
You don't have it. Where did you send it?
I believe I sent it to Ms. Reynolds and then also to the courtroom email, but if there's another address I should send it to, I'll be happy to resubmit it. And I'll send it to APA Movsifsian as well.
You didn't send it to 538, did you?
I did not. I sent it to 234.
Okay. Can you resend it because we don't have it?
Yes, I'll do that as soon as I log off.
Okay, thank you.
Thank you very much. Mr. Taylor, you are all set.
What date?
March 8th at 9:45.
Okay.
So am I able to go to court? Am I able to go to work?
Yes, Mr. Taylor. Once the judge signs the order and it's submitted, the hours will be amended.
All right, so I will be notified.
I'll give you a call.
All right, thank you. Appreciate it.
Mr. Noakes, good morning.
Good morning, Your Honor. I just wanted to give you the courtesy of letting you know that I have an exam at 9:30 for Mr. Norman Schroeder. In all likelihood, because I have two other matters at circuit court, I will be late.
I think you should probably be late to circuit court. Come here first.
Excuse me, Your Honor?
I think you should be late to circuit court and come here first.
Well, if I can get in at 9:30, I would do that.
Okay. Sounds
all right,
good.
Thank you, Your Honor.
Mr. Manugian.
Good morning, Your Honor.
Good morning, sir. How can I help you?
Judge, I have two cases up this morning. The first one is Sean Davis, which I have not been able to get a hold of Mr. Davis. His phone is going straight to voicemail. And I also have Ari Hollins, who is in custody. I asked to have this matter set for this morning. It's a PCC.
Okay. Bear with me. Let's take one at a time.
Okay.
This is case number 2355635. The people of the state of Michigan versus Sean Davis. Count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, assault with a dangerous weapon. Count 3 is domestic violence. Today's date and time is set for a probable cause hearing.
Appearances for the record, please.
Good morning, Your Honor. Sonam of CCN on behalf of the people, P83923.
Good morning, Your Honor. Max Manugian, P76341, appearing on behalf of Sean Davis.
Okay, what's your pleasure, Mr. Manugian?
Your Honor, I have no information that Mr. Davis is in custody. I've been unable to get a hold of him. I was appointed on this matter last week. If I would, at this time, I would ask for an adjournment.
So what's your plan?
My plan, Your Honor, is to engage one of the IBSD expert or investigators to track him down.
Keith locked up, sir.
He's in custody, Mr. Manugian.
There we go. That's I was.
Thank you, officer.
That would be the case. Is he on the screen today?
I don't think so.
I can them to bring him on, Your Honor.
Sorry?
I can wait for them to bring him on.
You're gonna wait? Okay, I'll come back to you. Ready on Hollins.
This is case number 2260000. The people of the state of Michigan versus, I don't want to miss the name of, so AIRRIE, last name Hollins. Count 1, homicide, attempted murder. Count 2, homicide, attempted murder. Count 3, second-degree arson. Today's date and time is set for a probable cause hearing. I'm sorry, a motion.
Appearances for the record, please. Do I not have an APA here on Hollins? Where is everybody this morning? Hey, Mr. Manukian, you're batting 1,000. We're not ready on Hollins either. Wayne County Jail.
Yes, sir.
Do you have a Sean Davis? Wayne County Jail, you have Sean Davis?
Yes, sir. I got him coming to the camera now, sir.
Thank you very much.
Judge, may I have a breakout room with him?
That's Sean Davis, Your Honor.
Okay, thank you. I'm gonna put you in the breakout room, okay? With your attorney.
I didn't hear you.
I'm gonna put you in the breakout room with your attorney. Hang on a second.
Yes, sir. Thank you.
Go ahead and join the breakout room.
Judge Kennedy is inviting you to join room 1. Excuse me, Mr. Scott.
Yes.
This is what popped up on this. This is what popped up. Okay, John.
Ms. Khalil.
Good morning, Your Honor. I'm here on Johnny King. Sorry, Johnny Young.
Oh, Johnny Young. Okay. That's set for exam at 11:30. Why are you here now?
Your Honor, I did reach out to the prosecutor and also reached out to the court. I didn't not have all of the discovery, the video discovery. So the prosecutor sent over video discovery on Friday afternoon.
Let me call the case.
Sure.
Yeah.
Want me to quote?
This is case 2355444, people of the state of Michigan versus Johnny Lee Young. Defendant is charged with count 1 larceny from the person
count 2 aggravated domestic violence. Appearances for the record, please.
Morning, Your Honor. Sonam Movsisian on behalf of the people, P83923.
Good morning, Your Honor. Simon Khalil on behalf of the defendant, Johnny Young. Mr. Young, can you please state your name for the record?
Johnny Young.
Your Honor,
Hey,
we
why
were-
are you, Ms. Khalil?
Thank you, Your Honor. We were scheduled for a preliminary exam, I believe at 11:30 this morning. I did not have all of the discovery in this case. I had reached out to the prosecutor, but the original prosecutor, Ms. Drain, was out of the office. So I reached out to a supervisor and ultimately was put in touch with Madam Prosecutor, Ms. Movsisian. She attempted to get the video discovery to me, and then on Friday in the afternoon is when it was made available to me. I wasn't able to view that video. It was giving me a message that indicated there is a video, but there's no content. But that was from my home desktop, so I haven't yet been able to view it to see if it works on my office desktop. So ultimately, I was going to need an adjournment. So I did reach out to the court and asked if I could appear by Zoom so we could adjourn the preliminary exam so I could review all of the discovery before proceeding. So that's basically where I'm at right now. And I haven't had a chance to review the whatever was sent to me on Friday afternoon.
You haven't had a chance to because you couldn't access it or because there's nothing there?
So I couldn't answer that. When I downloaded the Axon link that I got on Friday around 7, it said there's video, but there's no content. And I didn't come back in my office over the weekend. I'm here this morning. I don't know what's there. Really what I would request to the court is if I could set this back for a PCC, because if there's an issue with this discovery, then I have to go back to the prosecutor or potentially file a motion.
People, were you able to look at this video?
Yes, Judge, I was about to pull it up. I believe it worked for me when I received it. I know initially we had a problem of locating it, but then I did, and that's when I sent it over on Friday.
Some content.
I know, so I'm gonna try to pull it up again. I think it might just be depending on what computer it downloads on. Generally, Axon links are more compatible with HP because of the applications that are required to view them. So I was gonna pull it up right now just to make sure that we have it, or to make sure that it, it works.
Okay, how about March 10th at 9:45, for example?
Yeah, I have no problem having it set for an exam. Again, my concern would be if I don't know what's in the video. So if I have an issue, I guess I would just reach out to the court and the prosecutor again. And I'll be there in person if I have an issue.
What kind of issue?
I want to make sure I have all the video. That's all.
All I need you to do is coordinate that with the prosecuting attorney. So March 10th, 9:45 is a good date and time?
Yes.
Will be continued.
Thank you, Judge.
And just for the record, Judge, the video does show on my end, so it just depends on what application defense counsel is trying to watch it, because there is content on the video that was sent to her.
All right.
Thank you.
Let's go back to Harper. Still there, Mr. Cripps? Recalling 220-576-7501 versus Deontay James Harper. Appearances for the record.
Good morning, Your Honor. My name is James Kehoe, and my P number is 82812 on behalf of the people.
Mr. Cripps, are you there? Okay, I get one and lose the other. Not sure what happened to him, Mr. Kehoe.
I'll track him down, Judge. I apologize.
Mr. Kenny, good morning.
Good morning, Judge. I got Miss Walker.
Okay. No, I
This is case number 2355649. The people of the state of Michigan versus Frida Walker. Count 1, home invasion. 3rd degree. Count 2, malicious destruction of the building. Count 3, domestic violence, habitual offender, 2nd offense. Today's date and time is scheduled for a probable cause hearing.
Appearances for the record, please.
Good morning, Your Honor. Sonia Mopsisi on behalf of the people, P83923.
Good morning, Judge Robert Kenny, appearing on behalf of Miss Walker, 35842. I have.
Tell us your name, Ms. Walker.
Frida Ferrari Walker.
Mr. Kenny.
I have paper discovery. If there's any digital. Ask for it. And
You're going in and out, Mr. Kenny.
I'm sorry. I got paper discovery. I don't have
595.
I don't have any digital. If it exists, I'd like it. And we're asking for an exam date.
All right, the court will continue to plead not guilty and set this matter for preliminary examination on how is March 13th at 10 o'clock.
Can it be a little earlier or a little later?
March 13th at 9 o'clock.
Thank you, Judge. That's great.
All right, bond will be continued. Thank you.
Thank you. Have a good day.
You as well. Mr. Davis.
Morning. Morning, Your Honor.
Sir, how can I help you?
I'm checking in on Hector Serta.
All right.
This is case number 2355579. The people of the state of Michigan versus Hector Shirley. Count 1, assault with intent to do great bodily harm less than murder or strangulation. Count 2, assault with a dangerous weapon. Count 3, weapons firearm. Count 4, weapons felony firearm. Count 5, domestic violence. Today's date and time is scheduled for a probable cause hearing.
Appearances for the record, please.
Good morning, Your Honor. Sonia Mopsisi on behalf.
Good morning, Your Honor. Maurice Davis, P76203, appearing with Hector Serta, who's present, appearing via Zoom. Mr. Serta, state your name.
Hector Serta. Good morning, everyone.
Good morning. What's your pleasure, counsel?
Judge, I'm requesting discovery. I don't believe it's been sent. I want to set another PCC for now.
Is there a possibility this may resolve itself short of an exam?
I'm not sure.
Court will adjourn the probable cause conference to March 9th at 8:30.
March 9th. Okay.
Will be continued.
Thank you.
Thank you. Mr. Davenport, or Ms. Davenport. Davenport. Davenport going once. Davenport going twice. Moving on. Ms. Belcher, good morning.
Good morning, Judge. You look nice today. I like your turtleneck.
Thank you.
I have a matter that's not on your docket. It's for defendant Miss Corbin. I spoke with your clerk, Miss Reynolds, on Friday. She told me to Zoom on to let you know that she put an order on your desk for review.
Okay. That's simple enough.
I thought so.
It's a stipulated order modifying tether conditions so that she can go to medical appointments. Is that right?
And my office, Judge.
And attorney's office, that's correct. So the record should reflect that the court has executed the order.
Thank you so much. I hope you have a good day.
Thank you, you as well.
Good morning, Judge. My apologies. I was actually finishing up on a record in another courtroom.
Oh.
CURIYOENNA, last name CORBIN.
Okay, Mr. Cripps, you ready now?
Yes, Your Honor, I am.
I didn't lose Mr. Kehoe, did I? Okay, I got it.
Nope, I'm here.
All right. Yes. Recalling 220-576-7501, people versus Deontay Harper. Appearances for the record, please.
Good morning, Your Honor. My name is James Kehoe and my P number is 82812 on behalf of the people.
Morning, Judge David Cripps, P 34972, appearing on behalf of Mr. Harper.
And you're waiving Mr. Harper's appearance?
Yes, I am.
This matter is scheduled for a competency evaluation, a competency hearing.
Yes, Your Honor. I did receive an independent report. I haven't had a chance to get it to either the court or Mr. Kehoe, but the report confirms the original report from the forensic center that my client is competent to stand trial. So I'm prepared to stipulate to his competency.
Mr. Kehoe?
If that's the case, Your Honor, I would stipulate as well.
All right, the court makes a finding that the defendant is competent to stand trial. What's your pleasure, Mr. Cripps?
We're asking for an in-court preliminary examination with just a little bit of extra time because we're awaiting the exam transcript of the co-defendant. You signed a court order for that, I believe, 2 weeks ago.
All right. How's March 14th?
Let's see. It looks like I have a jury trial the day before. I'm not sure whether it's going or not. I better not take a chance.
March 21st?
I definitely will be in trial that day, Your Honor. We could try the 14th. I just have to keep Mr. Kehoe and you updated the day before.
I don't like to break like that. When I said something, I like to think of it as a big in stone. March 23rd. Any time of day.
Your Honor, I start a jury trial the 22nd. That's definitely going. I apologize.
You guys are making life hard on me. March 16th wasn't good.
That's good for me if it's good for Mr. Cripps, Your Honor.
Would that be in the morning, Judge? I could do it in the morning. I have a federal sentencing in the afternoon.
Okay, March 16th at 10 o'clock.
Yes, Your Honor.
Yeah, man, he's on the way down.
Yes, Your Honor.
All right, March 16th at 10. Will be continued. Thank you.
Thank you, Your Honor.
Ms. Davenport?
Hi, good morning, Judge. How are you?
Good, how are you?
I'm pretty good. I'm actually I'm requesting to stand in on LaRon Murray. If the court would allow. If not, then I can switch off with Attorney Davenport, who is the appointed attorney on this case.
Why wouldn't I allow you to do so?
I'm sorry, Judge. Oh.
I'll allow you to.
Well, there seems to have been a little bit of a misunderstanding. Attorney Davenport was under the impression that the exam was scheduled for today and not the PCC.
Let's set for PCC.
Okay. Well, I am prepared to stand in.
This is case number 2355432. The people of the state of Michigan versus LaRon Murray. Count 1, weapons, firearms. Count 2, assault with a dangerous weapon. Count 3, weapons, firearm. Count 4, weapons, felony firearm. Count 5, domestic violence, second offense notice. And habitual offender, fourth offense notice. Today's date and time is scheduled for a probable cause hearing.
Appearances for the record, please.
Good morning, Your Honor. Sona Movsisian on behalf of the people, P83923.
Good morning, Judge, to you and your staff. May it please this honorable court. Justina Shabazz Davenport, P number 82743, appearing on behalf of Mr. LaRon Murray, and I am standing in for the attorney of record, Curtis Davenport.
What's your pleasure?
Judge, we would actually ask for an examination to be scheduled, and I would also like to address bond.
The court will continue to plead not guilty and send this matter for preliminary examination.
Judge, may I make a note for it before you set the preliminary exam date?
I need you to put the stuff in.
Go ahead.
Judge, upon speaking with the complainant, she requested that the exam be set after March 13th, if possible, for her availability. I believe she is going to be out of town. And so she did request that I ask the court if there's a date that we can do after March 13th for the preliminary exam.
You can do March 15th at 10 o'clock.
Judge, Judge, I'm actually requesting for an earlier date. My client, he's actually been in custody for over 2 weeks now, and he's still in custody, remaining in custody. We originally were under the impression that this date would be for the examination, as Mr. Murray was requesting an earlier exam date. He actually does work, and understanding that these are serious charges, we would like to have the exam date as soon as possible so that he may get out on bond, et cetera. And if the court is inclined to actually schedule this after March 13th, we would ask to address bond with a tether or without a tether, but we would ask for Mr. Murray to be released out on bond.
March 15th at 10 o'clock.
Let's see. That's actually a great day, Judge.
Okay, the court finds good cause to go beyond the 14-day rule. March 10th at 10 o'clock, I'm sorry, March 15th at 10 o'clock. As the bond, hasn't his bond been addressed already?
Not by Attorney Davenport, and I do not have any notes that bond has been addressed, Judge. I believe that he was just arraigned, and then we had the probable cause conference.
Termination hearing, probably before Judge McConaughey.
I'm sorry, Judge, I did not hear that.
I said, I'm sure he's probably had a bond redetermination hearing before Chief Judge McConaughey.
After speaking with Mr. Murray, Judge, I do not believe that he has had his bond addressed. At least not by this court or by Attorney Davenport. As far as for Chief McConaughey, we had a jail visit with.
He had one on February 6th.
And who? February 6th, and was that after the arraignment, Judge?
Yes.
I have,
You have this new procedure in place after the defendant is arraigned, and if he's given a bond that he can't meet, then we give them a bond redetermination hearing that is usually handled by Phil Reagan of the Misdemeanor Defender's Office. And that goes before Chief Judge McConical presently.
may I ask what his current bond is currently, Judge?
$7,500 cash surety.
And that was lowered, may I ask what that was lowered from, Judge?
I don't know if it was lowered at all.
Yes, I'm here. Attorney Davenport has also indicated that it was not lowered at all, Judge. That was the initial bond.
I think that's what I just told you.
So I'm asking for so is that a bond redetermination? Because I'm a little bit confused. I know that you said that it was addressed and it was a bond redetermination.
That doesn't ensure that the bond is going to be lowered, but the judge entertains arguments as to what the bond should be. Sometimes it's continued, sometimes it's lowered. In rare instances, it's increased.
Well, Judge,
so came before Chief Judge McConical and he declined to reduce the bond.
Okay, well, Judge, now that we have a new set of information, I would ask that I may also argue bond again. I mean, again, Judge, he's been in custody for over 2 weeks, and it sounds like he's going to be in custody for another, at least another 10 days minimum.
What's the new information?
Well, the length of time, Judge. He's supposed to have he has a statutory requirement to have his exam within 7 days of the arraignment, and right now it's been already 14 days, and it sounds like it's going to be another 10 to 14 days.
That's unless the court finds good cause to go beyond those 7 days, which I do, which I have.
Well, Judge, so with this new procedure, I believe I also did do the training on the new bail project, the way that the bail is addressed. I don't recall anything about how to actually request a reduction in bond when there's just no bond reduction at the arraignment. May I inquire with the court? What are the procedures? Do I need to request a DSU report to argue for bond to be reduced, or is it just set from here all the way to Third Circuit Court?
Okay, so after the defendant is arraigned, and if he's given a bond that he can't meet, then it automatically goes before the chief judge for a bond redetermination hearing. The chief judge determines whether or not he's going to reduce the bond or continue the bond. And then it proceeds to the probable cause stage, which is where you are now. You brought the issue up of bond again, and I'm asking what conditions have changed since the chief judge made his last determination as to what bond should be.
Well, I guess, Judge, two things. It sounds like the complainant would be unavailable within the statutory requirements. So I understand that the court has found good cause to go beyond the 14-day requirement. And additionally, Judge, there's a new attorney on the case, and so I am not sure what the previous attorney has argued as with regard to bond. However, I would like to have an opportunity to argue bond, seeing that Mr. Murray has been in custody for quite some time. He is gainfully employed. He actually has his own business, and we would even ask for a tether requirement. But Judge, I would even also ask, how exactly do we entertain another redetermination of the bond, seeing that he's in here for so long?
You're asking me to reduce the bond right now. You're doing it.
Okay. All right, Judge.
All right. So I'm looking at this defendant before me. He's a habitual offender, fourth offense notice. He has a felonious assault from 2003, felony firearm from 2012, and a drug case from 1996. He's charged with being a felon in possession of a firearm, assault with a dangerous weapon, and domestic violence second offense notice. All that being considered, it sounds like the defendant may be a danger to the community. And I'm concerned with these allegations of possessing a firearm and the assaultive nature of this case, and this being a felony firearm second offense notice. That concerns me more so than the habitual fourth offense notice. People, what say you?
Sorry, say that again, Judge.
I'm looking for you to weigh in.
Yes, Judge. I mean, you pretty much stated what my argument would be. I don't even bond is that excessive. You stated it was a 7,000 cash surety.
7,500 cash surety.
7,500 cash surety.
It's actually pretty low.
Yes, and so
History.
exactly. That's what I guess I'm confused at. I mean, what it sounds like defense counsel is requesting is a personal bond, and I don't think that's appropriate in the situation, given his the charges involving the firearm. And as you just stated, he does have a prior history of a felony firearm and a felonious assault. I have spoken with the complainant, or sorry, I have not personally spoken to the complainant. AP Drain had spoken with the complainant, and she has significant concerns for her safety. She plans on appearing at this court date. I think that what bond is set at currently is appropriate, and I would not, and I would oppose anything to go lower than what it's currently set at.
And Judge, if I may weigh in very quickly also.
Okay, go ahead.
Thank you, Judge. I actually do not have access to all of the late information that you actually just stated on the record, so I do thank you for that. However, it does sound like he has not had any recent contacts with the criminal justice system at all. It sounds like the most recent has been over 20 years, or at 20 years. I believe I heard 2003, and prior to that, I heard 1996. So, Judge, with that being taken into account, I would believe that he would not be a danger to society. The United States is we have a rehabilitative criminal justice system, and it sounds like he may have very well benefited from it, Judge. The charges that he stands accused of right now are only accusations. He is presumed innocent until proven guilty, and I am not taking light weight of any of the charges, as they are still serious charges, Judge. However, I do not believe that he is a flight risk. I do not believe that he is a danger to society, and I do believe that even a GPS tether would ensure that he stays away from the complainant, especially since she's going to be out of town until March 13th anyways. So, Judge, I would just request a reduction in the bond. 7,500 for this case does sound excessive. Even seeing that he is a fourth habitual, it sounds like some of that comes from a drug crime, so that's not even violent charges. And the other one is felony firearm. So this is a felony firearm second. But again, it's been at least 20 years between the last incident.
Judge, I believe the dates are wrong. His last incident was 2012, so it's only been 10 years.
10 years is still a lot.
Bond will be continued. I'll refer to pretrial services for bond recommendation.
I appreciate it, Judge.
Exam stage.
I appreciate it.
Okay, thank you.
All right, thank you. You all take care.
Ms. Belcher.
Good afternoon, Your Honor.
How you doing there, Ms. Upshaw? What can I do for you?
Your Honor, I am setting a date on Mr. Rumel Walton.
Okay, let me call it.
This is case number 2355632. The state of Michigan versus Romeo Walton. Count 1, homicide, murder, first degree, premeditated. Count 2, weapons, felony firearms. Today's date and time is scheduled for a probable cause hearing.
Appearances for the record, please.
Good morning, Your Honor. My name is James Kehoe, and my P number is 82812 on behalf of the people.
Your Honor, Randall Upshaw, P number 43574, on behalf of Mr. Walton. Your Honor, we're asking for an exam date, or even though I haven't received all of the videos, And Your Honor, I know that my case is much more serious, but it's an individual case. And at one point, I would like to address the issue of bond, even though I don't know if today is correct. But we're gonna set a date, Your Honor. Thank you. And if there's any videos, I would expect them from the prosecutor. And I would like to still address the issue of bond. Thank you.
How's March 14th?
What time on March 14th, Your Honor?
What time of day is best for you?
Your Honor, how about, matter of fact, I can get there early because my hearings are there. Anytime in the morning, Judge.
March 14th at 10 o'clock?
That sounds great, Your Honor.
Your Honor, do you have the 11:30 open? I do have a few matters at circuit that morning. That's going to take me to 10 at least.
Okay, I can do March 14th at 11:30. How's that, Mr. Upshaw?
That's fine, Your Honor, and thank you.
Right.
Mr. Upshaw, I'm going to contact you later today about the rest of that discovery.
Thank you. Judge, as much as I respect this honorable court, and I think the prosecutor would be agreeing with me on certain points, and that's why the reason I'm addressing bond. Mr. Walton is a victim against the deceased in Frank Murphy Hall of Justice. Mr. Walton has made 3 requests to the prosecutor's office, provided videos to the prosecutor's office, made 2 requests to Judge Vonda Evans, asking that the victim in this case be ordered to be locked up, bond raised because he was in violation of his bond. The victim in this case, as part of his bond, was asked to stay off the block, away from my client. My client and his wife and his mother all sent videos to the prosecutor's office saying how they was threatening him. I have a video of the victim pulling a gun, making him get down on the street while he was still on bond. Judge, it's alleged, and if the prosecutor wishes to agree on any of these facts, please do. The allegation on this case is that the victim, again on bond, but it's no contact or with my client, followed my client on his block to the Coney Island, went inside and made a threat. And in response to the threat, it's alleged that my client shot him. I think those facts are very unique and different. That's why I would just ask for consideration if the court deems this appropriate time.
I didn't look at that phone number that came up. I don't know where no calling.
Mr. Kehoe.
Your Honor, I do agree that there were cases between the 2 individuals, but the issue I take with the recitation is that both individuals were in the Coney Island. However, the deceased in our case is walking out of the building when the defendant pulls out a gun, walks up behind him, and shoots him in the back of the head, Judge. This isn't a combatant sort of situation. The victim in this case was actually walking out of the building when he gets popped in the back of the head. So, Judge, I disagree. I think the allegations and the charges in this case are more than warranted, and I would request that this court take no further action on bond.
And just for the record, I would ask for the copy of the Coney Island because it's my understanding that the witnesses in the Coney Island stated that the victim, I'm grabbing my gun and you won't make it out of here. Nothing further.
Sounds like it's going to be a very interesting exam. I can't wait to see it. I'm hearing varying stories as to what took place. It does give the court some pause that the defendant here is a victim of the deceased on some other occasions. I would be very interested to see this video evidence and any words that were spoken in the light. I'm inclined to leave bond where it is right now We can address it again at the preliminary exam after I've had the opportunity to view people's evidence. We can address bond at that time if need be.
Thank you for the consideration, Your Honor.
All right, thank you.
Thank you.
Have a good day.
You too.
Good morning, Judge. How are you?
How's the stuff?
Yeah, not bad. I have a 9 o'clock in here, but I also have a 9:30 upstairs with Judge Debris. I was gonna suggest just doing a check-in on that one. Not sure. Okay.
Oh, yeah. Calling case 2355474, people of the state of Michigan versus Frank Eddie Mathis. Defendant is charged in count 1 aggravated assault. Appearances for the record, please.
Good morning, Your Honor. Neighborhood Defender Service of Detroit by Natalie Phelps, P83355, with your on behalf of Mr. Mathis, who is also in the courthouse, and I can grab his throat.
Judge, good morning. Sonam Lofsisian on behalf of the people. If we're getting into the exam schedule, I would like to head over to conduct those in person. So if you would give me 5 minutes, I'll be right there.
Well, before you do that, do the people have witnesses here on this case?
Yes, I should. I have spoken to the complainant on this case and she should be there. So I would like to appear in person there to see whether or not she's in the hallway.
Security, do we have a Dominique Bell here?
Is that for the Mathis case, sir?
Yes.
I believe we got one witness.
Okay, yes, so come on over.
Okay, thank you, Judge. I'll be right there.
If you want to hold on a second, Your Honor, she is here, Ms. Bell, and this will be a waiver.
A waiver, okay. Where's your client?
Okay.
Judge, I don't know if Ms. Mosisian is going to be handling the Sean Davis matter, but we just want to set an exam date on that one.
Hey, you gotta wait your turn now.
Judge, I would like to handle the waiver in person. Is it okay if I head over right now?
Is there any particular reason why?
Just so I can have the opportunity to speak with the complainant about the situation before we agree to that waiver.
All right.
Okay, I will be right there. Thank you.
I don't know why they just don't come here first. Who is this in the DRF hearings 2 West? What's your name, sir? Unmute yourself and tell me your name. DRF hearings 2 West. Unmute yourself and tell me your name.
Gary Hollis.
Yes, my name is Katone Scott.
I don't see Mr. Scott on my docket today.
Ari Hollis. My name is Ari Hollis.
Yes, Ms. Hollis, I'm not talking to you yet.
Okay.
I thought we did that case before. Was your case bound over? Have you had a preliminary examination, sir?
No, sir, my case was never bound over. My attorney was Wyatt Harris. Like 2 weeks ago, he's supposed to be getting some information because this case supposed to have been handled with my prior case, but so somehow it keeps showing back up.
Right, I believe that Mr. Harris appeared on your case last week, and he told me that he was unable to resolve it, and we set it for preliminary examination. So you don't have anything set with me today. I think we already set your matter for exam. Spell your first name for me.
Catone.
CATONE. Scott Madison.
I think I might spell it wrong. CATONE. Scott?
Yeah.
Since 21. I don't see anything.
Maybe back on somebody else, but she's still on there.
Excuse me, on the Galaxy A715G, stop unmuting yourself till I call you, okay?
March 10th, 1:30.
March 10th at 1:30, Mr. Scott, is your exam date.
Okay.
So you'll be rated out to be here with us live, okay?
Yes, sir.
You're all set, sir. Thank you.
Thank you.
Yeah, we called this.
We did call her. Well, that was both of it was her and Sean Davis. Max's. Right.
Okay, Mr. Manugian is back.
Right.
Okay, Mr. Manugian.
Yes, Judge.
Prosecutor on Thomas.
I am.
Who is the prosecutor?
Prosecutor, I believe, Your Honor, in this case, we actually don't know. I think it's Shelley Drain. I've been in contact with numerous people at the prosecutor's office.
It doesn't do homicide.
I'm sorry?
Shelley doesn't do homicides.
And so with that being the case, and that's why I've been in touch with many people at the prosecutor's office. It appears that there hasn't been an APA assigned to it yet, but Ms. Drain was helping out for the very complex issue that arose that I wanted to illuminate the court to.
And you said you wanted to wait on Davis. What's your name, sir? Unmute yourself and tell me your name.
That's Sean Davis, Your Honor. And that's Mr. Davis. And we just wanted to set an exam date on that one.
Hey, how you doing, Judge, Your Honor?
I'm good, sir.
Hey, my name is Sean Davis.
Okay.
And we have two there. We have a person, 2-year-old. Terrence. Sheldon. The first two. How you proceed on those?
We're just waiting on the prosecutor to walk through the door.
No problem.
Meantime, I'm going to try to find your homicide prosecutor, okay?
Thank you, Judge.
Come here. I know we need navigation stuff.
Hi, Judge. Sorry, I actually want to get the name of the prosecutor on the case.
It's gonna most likely be Shelley Drain. She'll be back next week.
Okay, well, if the prosecutor handled the case today, I just wanted for her to make a note that we don't have the digital discovery. If she can send that over. I'm not sure if she's still in the courtroom.
No, she's actually on her way over to the court.
Okay. Do you mind passing it along for me, Judge?
Trying to put me to work?
I'm trying to. The day goes by faster when you're working.
That's on Murray, right? That's on Murray, right?
Yes.
Digital discovery?
Yep, digital.
Okay.
Thank you.
All right.
Take care.
You too.
So right now, this means, sir, I think the person about GPS. I'm not gonna be recording.
Okay, attorney, sent to the voicemail 3 times, so I left a message. Attorney Roberts did answer. He said that's not his case, but he's gonna call the person whose case it is.
He's still on the record. He's still on. Of course. Have anybody here for our 9:30?
Yes, Your Honor. First, the prosecutor, she just went in to talk to the on the first case. 9:30, the attorney and the defendant.
Sir, on the Galaxy A71 SG that keeps unmuting himself. What's your name? What's your name, sir? Now you don't want to talk after making all that noise. What's your name?
Oh, Sean Davis.
Not you, Mr. Davis.
Oh, I'm sorry, sir. I'm sorry, Your Honor.
It's okay, you're okay. I'm gonna mute you though, okay? What's your name, sir? Sir, with the glasses on, elder gentleman. Yes, you. What's your name? No, not you, sir. Telling you, not you. What's your name? One just took his glasses off. What's your name?
Oh, William Hollins.
Thank you, Mr. Hollins. Oh, all right. Why are you here, Mr. Hollins?
My daughter, Ari Hollins.
You have to view this on YouTube, sir. Where it's being
YouTube?
live. Yes, sir.
Judge, they're the complaining witnesses on this case, and I believe they're going to want to make some statements.
What kind of statement?
Related to Miss Hollins's health condition. She has a terminal brain tumor, and she has medical needs that are not being met in the jail.
So what do you ask?
Well, Judge, ultimately what I'm going to be asking for, and not to get into the case too much, we had originally, when this case was originally, at first I had this matter set for a competency review, and then the health issue was brought to light to me by Ms. Hollins's parents. At this time, we would like to have this matter set for a preliminary exam. And I would like to address bond.
Okay. I need to get the prosecutor in. Let me get the prosecutor. She's on everything. She's holding me up. That's it.
Hello, Judge.
Good morning. You're clogging my docket up, people. Frank Mathis. Calling case 2355474, people versus Frank Eddie Mathis. Defendant is charged in count 1 aggravated assault. This matter is scheduled for preliminary examination. Appearances for the record, please.
Good morning, Your Honor. Soto Maltese on behalf of legal P83923. Good morning, Your Honor. Name is Defender Services Detroit by Natalie Phelps, P83355 on behalf of Mr. Mathis. Judge, you just walked in. I would like a moment to speak with him briefly. He has
What
been
have
here.
you been doing all this time?
Your Honor, I told you I had another case at 9:30 that just got dismissed. So again, I've been here since
I know,
before
you've
9.
been here and plenty of time to talk to him.
No, I have talked to him, Your Honor. I just wanted to have a moment to speak with the prosecutor and then for a minute he wants to wait. I'm not gonna put him on the record and then, have a. Just 1 second, Judge. Can I speak?
Mr. Notes, I bet you're ready, aren't you? Yes, sir.
Thank you, Judge. Sorry.
Back on the record on People versus Frank Mathis. Appearances, please.
Again, Your Honor, Sotomayor, CC on behalf of Natalie Foch on behalf of Mr. Mathis, who's also present in the courtroom. Mr. Mathis, can you please state your name for the record?
I gave him up.
There's date, time set for preliminary examination. Are you ready to proceed?
Your Honor, Mr. Mathis would like to waive his exam. Sorry.
Sir, please raise your right hand. You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God? Sir. Thank you, sir. You understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one, and you'll be bound over to Wayne County Third Circuit Court as you stand charged in the complaint form. You understand that? You understand the nature and the purpose of a preliminary examination? Yes, sir. You understand if you were to have one, the prosecution would have to establish that the crime you're charged with was committed in the city of Detroit, that was probably committed. Yes, sir. Is anyone forcing you to waive the right? Yes, sir. Has anyone promised you anything? No. Are you waiving your right freely and voluntarily? Yes, sir. Any objection from the people?
No, Judge.
The court finds defendant's waivers made knowingly and voluntarily freely given. The court finds to Wayne County Third Circuit Court, Criminal Division for further proceedings. His arraignment on the information, date, and time will be March 13, 2023 at 9:00 a.m. Will be continued.
Thank you, Judge. Thank you.
Thank you. Did he sign the waiver?
Oh, no, Judge, sorry.
All right, Mr. Brooks.
Yes, let me know. Thank you.
You must have had an exam already set.
Thank you.
A little older.
The attorney who just left?
No. Norman Schroeder. Calling case 2355492, people of the state of Michigan versus Norman Schroeder. Defendant charged in count 1, unlawful imprisonment. Count 2, domestic violence, third offense notice. Appearances for the record, please.
Good morning again, Your Honor. Someone will see 8392.
May it please this honorable court, William Noakes, P42796 of the Neighborhood County Service of Detroit, on behalf of Mr. Norman Schroeder, who is present in the courtroom. Please tell the judge your name, Mr. Schroeder.
All right, please take the time set for preliminary examination. Are we ready to proceed?
Judge, if people are not ready to proceed, I did attempt to contact the complainant last week. I had actually spoken with her initially when this warrant was authorized. And I had a couple of phone numbers for her, and unfortunately, neither one were
She didn't answer neither one of those phone calls. I did leave voice messages in regards to today's date and time, and it is now almost 9:50, and she is not present in the court today, so we are unable to proceed without her.
Your Honor, dismiss, so ordered, the court will dismiss this matter without prejudice. I need a dismissal order. On that case that waived, I didn't sign behind the lady.
Carry got the order.
Now this son told you.
Judge, good morning. Good morning, everyone.
Hey, there he is, Mr. Glenn. How are you, sir?
I'm good, Judge. Pardon my lack of time. I wasn't supposed to be in court today. I don't exactly know which matter is up, Judge.
So I think we have a Miss Collins, Mr. Manugian.
Judge, is that Ari? A-I-R-R-I-E?
Yes, sir.
Pronounced Airy.
Oh, Ari. I apologize. Judge,
No
that's
problem.
not a homicide unit case.
Whose case is it?
It appears to be a general prosecutor. This is an attempted murder case, not an actual murder. So we wouldn't handle attempts. The warrant was signed by a general warrants prosecutor, and the last prosecutor of record on here is Ms. Drain. So I'm not exactly sure who handles it. I mean, is it something that I can stand in for, Judge, or is this a substantive hearing?
Well, I have a general prosecutor here, but the reason I thought it was a homicide case because our register of actions listed as a homicide.
Totally understandable, Judge. Yeah, I'm looking at the charging document. It says homicide, attempted murder, 2 counts, and then arson in the second degree. Is that the same case?
Yes.
Okay. Yes, Judge. That actually won't be our unit. I would imagine it'd be the general prosecutor at this point because we don't have an arson unit.
All right. So Mr. Manugian was correct, and this will be Shelley Drain's case. Thank you, Mr. Glenn. I appreciate you.
No problem, Judge. Anytime. Have a great day, everyone.
Thank you. You too. So do you have the Hollins case, Ari Hollins?
Judge, I don't have it on my docket, but again, because this is coming, it was kind of before if there was something was added recently, that's probably why, but depending on the charge that I can take care of it.
Well, it's an attempt homicide.
Oh, then no. That would not.
I mean, it may be if it has a domestic violence component. Let me see that.
I know it's a little bit off. What was the name, Judge?
Ari Hollins. This may not even supposed to be in this case in this court at all. But actually, I think.
Can I speak, please?
No, ma'am. I think.
Okay.
The complainants are the parents. Is that right, Mr. Manugian?
That's correct, Your Honor, and that is who just asked to speak.
So that would be.
It wouldn't be my unit. We only do expect from your violence. So if the complaints are the parents and the defendant is then related to them, then that like child or would not be handled by the domestic violence.
So who's going to be handled?
That's usually just our general warrants division, but I'm gonna look up the case right now and see if it's, see if it's. Can I get a spelling on the last name?
HOLLINS.
First name?
AIRRIE. Middle name Denise.
Mom and Dad, what did you want to say to me?
I'm her mother, and I wanted to say we wanted to drop all charges because she is mentally ill. She have an enlarged tumor in her head that Dr. told me last year. He gave her like 12 months to live. And so we appreciate it. If you could just drop the charges.
Judge, the case in our system, it just is assigned to the district court, which means it's handled by the general warrants division. So whoever is usually here that making payments or cases for the general docket, by now we don't get those. Yeah, so I'm not quite sure. It's not within our unit. So that's.
But I'm inclined to go ahead and do this. It's here. The complainants are here, the defendant is here, her attorney is here. Complainants are indicating they don't want to go forward in this matter because she has a terminal illness. So, ma'am, this case gets dismissed and your daughter gets out. What happens then?
The only thing I can do is she got a permit on March the 10th to go get her MRI did to see if it's strengthening. And the only thing I can do is just take her in and try to get a doctor permit to try to help her.
My concern is for you and your safety. So how am I to be ensured that nothing else is going to happen?
I really believe that the Lord is not going to let nothing happen to us.
Oh, I'm sorry, I thought we were on. Calling case 2260000, people versus Ari Denise Collins. Defendant is charged in count 1 homicide, attempt murder, count 2 homicide, attempt murder, count 3 second-degree arson. Appearances for the record, please. Go ahead.
I didn't understand.
Good morning, Your Honor. Sona Mosisian on behalf of the people stepping in on this case P83923.
Have to unmute yourself, Mr. Manoogian.
I'm sorry, Judge. Good morning, Your Honor. Max Manoogian, P76341, appearing on behalf of Ari Hollins.
Okay, so we've had some off-the-record discussions. The complainant's mom, the mom and dad of the defendant are here. They are the complainants in this matter. This case isn't even supposed to be before this court. This is supposed to have gone through the general warrants division and gone to one of the other courtrooms. I mistakenly thought this was a homicide, but it's not, thank God. But in any event, it doesn't meet the criteria to be before this court. Yet in the same, I have the complainants here. Tell me your name again, ma'am.
Nellie Hollins.
And who is that you have with you?
William Hollins.
Tell me your name, Mr. Hollins.
William Hollins Jr.
All right, they are the parents of the defendant, and they tell the court that the defendant has a terminal illness, and they don't wish to proceed in this matter.
Judge, if I may.
Yes.
In our records, it indicates that this was referred to for a competency evaluation on January 25th. Are you aware of whether or not that was
Mr.
completed?
Manoogian mentioned that earlier. He said that he does not wish for it to be referred any longer. He wanted to set it for exam.
Okay.
And I suspect he wants to do that because he knows that you don't have cooperating witnesses. If it was referred, then you're talking about 90 days down the road. She's in Wayne County Jail right now not getting the proper medical care that she needs for her terminal illness.
And what is her terminal illness?
She has a brain tumor.
Okay. Judge, I mean, I'm not familiar with this case. I really don't feel comfortable making a decision on whether or not it should be dismissed at this point. I hear the complainants. I think it would be maybe more appropriate for either a victim advocate or one of our prosecutors to follow up with them to talk to them about this process and the potential safety concerns, especially if this case is dismissed. The other thing I see is that there's a court hearing scheduled on April 25th. I'm not sure what that's in regards to.
That's probably the competency.
The competency, okay. But Judge, again, just based on the fact
I
that
think
I'm not.
whoever this is ultimately going to be assigned to needs to have some very meaningful discussions
Yes.
with the planning witness and Mr. Manubian and get this matter resolved as quickly as possible so that she can get the medical help that she needs.
Yes, Judge, I definitely agree with that.
Judge, that's why I said this today. I wanted to get this back on the calendar today. I figured the best way to force the issue on getting a prosecutor assigned to this would be to set this matter for exam. So I would ask if we could set this matter, if we could cancel the competency review. And there has been no interview conducted nor scheduled to my knowledge. I would ask if we could set this matter for exam as soon as possible. And I mean, if this week, that would be what would be best given the dire circumstances involved.
I don't think I can do this week.
If not, Your Honor, I would also ask to address bond.
I can do March 8th at 1:45.
I could do that, Your Honor.
So the competency evaluation will be withdrawn. Set for preliminary examination on March 8th at 1:45. Now you wanted to address bond, but my concern, Mr. Manubian, is it sounds like the complaining witness is the home of the defendant. And I'm looking at these charges here, and I'm looking at arson and attempted murder. So that gives the court some pause.
Judge, just so you know, I don't know if the court is aware, has the investigator report. The basis of these allegations is that she lit a bed sheet on fire. That's the allegation in this case. There was no conduct upon either of the complaining witnesses. There was no further, the house did not catch on fire. It was simply that a bed sheet was.
Assault with intent to murder out of setting the bed sheet on fire?
Correct.
I think I can't speak to that. I have no idea who charged this or what their the reasoning behind it. I've been looking at the report. It does appear that there were bed sheets set on fire, whether or not the attempted murder charge comes from the fact that maybe, like, I don't know enough of the facts to know if the parents were sleeping in the home, if the intent was to set the house on fire with them in it. I mean, it's, as someone that just is unaware of this case, I don't know why it was charged the way it was. And it sounds like the people in the home were unable to escape through the front door, so I think there were issues in regards to the fact that this fire was being set in the house while there were occupants in that home.
Okay, just for purposes of this bond motion. Ms. Hollins, what happened?
Well, what happened that night, I gave her a medication and she went to bed and went to sleep and then she woke up and she was just walking around the house and I kept asking what she was doing. She said nothing. And me and my husband was laying in the bed and I heard the front door and I knew she had walked out the door. So he got up. I told him to get up and check and see that she locked the door. And that's when we discovered the fire blazing and we had to try to put it out. But she's seriously mentally ill and she haven't been taking her medication since 2020.
But you
And
said
she
you
have a
gave her-
lot, sir.
You said you gave her the medication and she still did that?
Yeah, but that wasn't her mentally ill medication. I don't have any, that's the medication for a tumor. But what I'm saying is she also is seriously mentally ill. I used to take her to the clinic. She bipolar and that she used to get a monthly shot in her arm. And that's the part that I'm talking about that she don't have that probably made her, go where
Okay,
she
so
went.
she's out of jail and she comes to stay with you. What assurances do I have except for you believing?
She can stay with her daughter, her oldest daughter. She can live with her. And I'll just be taking. Sir?
I don't want her setting her house on fire either.
Well, I don't know. She needs to really get back into Miss Stevenson is her psychiatrist. And I've been calling her, but she's retired from the clinic. And she needs to get another.
I don't think she'll do it again.
I don't think she'll do it again, but she needs to get another psychiatrist, but she can get back on her meds for her mentally problem.
You see, I don't want anything catastrophic happening here. I let this defendant out on bond and she hurts one of you guys.
Judge, I don't think she would do it again.
You didn't think she would do that the first time, did you?
No, I did not.
Okay, so that doesn't hold a lot of water with what we think she may or may not do. We don't know. I need some assurances here.
I can't 100% guarantee you, but I do know I'm covered with the blood. And so that's why I'm not afraid to let her out.
Ms. Hollins, will you take her directly, if she's released, take her directly into a mental health institution to get her seen by a doctor?
I've been doing that and I'll try it again. Every time I place her somewhere, they don't even keep her that long. They don't give her no medication. They just let her right on back out. Yes, I do. I'll try.
You do understand that's not very comforting to me either, Mr. Moody.
I understand, Your Honor. Ms. Hollins, obviously, Judge King is very concerned for your safety. If the best way for you to ensure your safety is to have her committed to a mental health facility, can you get her there as soon as she's released?
I can't. Yes.
Your Honor,
the first she said is I can't. You can't what?
Right now, I just can't think of who I could just call and have a place. Like.
Are you her guardian?
I was her guardian, but she some kind of way she got a lawyer and had me offer her. And how that happened, I don't know, because I never signed off on anything.
Judge, if I may.
Yes.
I think just given what has been said, actually a competency evaluation is probably extremely appropriate. And the reason I say that is because generally, if she is in fact in the position that she indicate she is able to work with her, to get her the resources and the services that she needs.
Well,
If
they're
they find
just,
her
they're just
in-
working with her to get her competent.
Yeah, but they generally will give her the like treatment medication and things like that. It's my understanding that that usually is part of the course.
She might die in jail before that review even takes place. That's the problem. That's why I wanted to bring this up as fast as possible.
Then I think what the other option is to try to get her into an inpatient treatment, but to not release her until we know that she has a place to go to, that is planned out between defense attorney and her parents, that they know that either a hospital or a psychiatric treatment will accept her and that they will keep her there, that the parents can even put her in to some sort of treatment. I don't think we should release her without a plan.
I agree. And I will indicate that in any order that she is to be released to some type of treatment facility to deal with her mental illness.
Could you gonna do that today?
I can prepare an order to that effect, or have an order, Mr. Manukin can prepare an order to that effect, that she's to be released to a mental health facility.
So, Your Honor, just for the purposes of the language of the order, would this be a personal bond with the requirement that she be released into a mental health facility for an inpatient stay?
Yes.
Okay, I can prepare that.
Appreciate it. Thank you. In the meantime, I'm going to adjourn this probable cause so we can get this to the proper judge that's going to handle this case, or at least get the proper prosecutor that's going to be here to handle the case.
Judge, I would just ask if we could keep that March 8th date for the preliminary exam. I think that we know where this case is headed eventually, and what is the best, the getting her into a mental health facility is of the utmost importance. But I think for this family, getting to that preliminary exam date is what is really important. This case, I believe, was not erroneously, but overcharged, to say the least. There are the complaining witnesses do not want to proceed. This is a family in grieving a defendant that is terminally ill. The slow gears of the justice system can really do a lot of harm in this situation to this family right now. And so the sooner that we can get in for a preliminary exam so that this case gets to where it's going, I think is in the best interest of justice.
Okay, so the defendant will be released to an inpatient mental health treatment facility. We'll keep the exam date of March 8th, 2023 at 1:45 p.m. Thank you much.
Thank you so much, Your Honor.
Thank you.
Thank you, Judge.
And Judge,
Okay.
what would be the email address to send this order to?
CTRM 234 at 36districtcourt.org.
Thank you so much, Your Honor.
Thank you. Oh, you still have one more with me, don't you?
I do, yes.
Davis?
Yep.
Ms. Hollins, you're all set, ma'am.
Okay, thank you.
Thank you.
Okay, I'll take it off then.
What's your name, sir, on the Vortex 7 or Z22? Unmute yourself, tell me your name.
Terrence Branson, Calhoun judge.
Mr. Calhoun.
Kenneth, can I have a breakout room, Mr. Calhoun?
All right. We're ready, Ms. Davis.
This is case number 2355635. The people of the state of Michigan versus Sean Davis. Count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, assault with a dangerous weapon. Count 3, domestic violence. Today's date and time is scheduled for proper hearing.
Appearances for the record, please.
Good morning, Your Honor. So I'm 16 on behalf of the people, P83923.
Good morning, Your Honor. Max Manugian appearing on behalf of Sean Davis, P76341.
Tell me your name for the record, sir. Unmute yourself, Mr. Davis.
Yes, sir. Here I go, Judge, Your Honor.
Tell me your name.
My name is Sean Davis.
What's your pleasure, Mr. Manugian?
Your Honor, today's date and time set for probable cause conference. We would waive, at this time, Mr. Davis does understand his right to a preliminary exam, his right to hold that exam within 21 days of his arraignment, and he does wish to have this matter set for preliminary exam at this time.
All right, the court will continue to plea of not guilty. We'll set this matter for preliminary examination. House March 15th at 10:30.
Your Honor, I am in person in court all day in Rochester that day.
March 13th at 10 o'clock.
I'm out of town that day, Your Honor. I'm sorry.
March 17th at 10 o'clock.
Your Honor, if we could do that later in the morning, that would work. I have a Zoom docket that morning, but it will likely be over by 11.
11 o'clock.
Could we set it for 11:30? Is that possible?
Okay, 11:30.
Thank you so much, Your Honor.
17th at 11:30. Fine, will be continued.
Thank you so much, Your Honor. And Miss Motsisian, do I have your permission to sign your name on that order on the Hollins case?
Let me reach out to a prosecutor that's gonna be handling it first before you do that, only because since it's not my case, I don't want to overstep.
Just send it to the court.
Yeah.
It's coming to the court. I'll sign it.
Okay,
Okay, thank you, Judge.
sorry, thank you.
Mr. Kenny, thank you so much for your patience, sir. You ready on Vance? Okay.
Yes, sir, my victim is present, if I may have a moment, please.
So Judge, Your Honor, what should I do from here?
You're all set, sir.
So what I need to do I get out today or I don't understand what I need to do.
Their examination is set for March 17th at 11:30.
Okay, so what I get, so how do I get out? Do I have a bond?
You're over here on March 17th.
Do I have a bond or anything to get out?
Well, your bond is the same, sir.
Okay, the personal bond with the tether?
That's what your bond was, yes.
Yes, sir, that's what it is, sir.
All right.
Thank you.
Mr. Kenny, are you waiting? Do you want to sign the waiver form for me?
I put it on top.
Calling case 2156712 for the state of Michigan versus Robert Darren Vance. The defendant is charged in count 1, criminal sexual conduct, 4th degree force or coercion. Count 2, criminal sexual conduct, 4th degree force or coercion. Appearances for the record, please.
Good morning, Your Honor. Someone will see on behalf of people, P83923.
Morning, Judge. Robert Kenny appeared on behalf of Mr. Vance, who stands to my left. 35842 is my appeal. Mr. Vance has indicated to me that he understands what a preliminary exam is and wishes to waive his right to it at this time.
Tell me your name, sir.
Robert Vance.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You understand you have a statutory right to have a preliminary examination by waiving the same. That means you won't have one, and you'll be bound over to Wayne County Third Circuit Court as you stand charged. You understand that?
Yes, I do.
You understand the nature and the purpose of a preliminary examination?
I do.
You understand if you were to have one, the prosecution would have to establish that the crime and charge which was committed in the city of Detroit was probably caused to be committed. Has anyone forced you to waive your right?
No.
Has anyone promised you anything?
No.
Are you doing so freely and voluntarily?
Yes.
Any objection from the people?
No, Judge, I just would like to make, for the record, the complainant, Williams is present. I did discuss with him the waiver and he is okay with that.
Court finds the defendant's waiver is made knowingly and voluntarily free to give. The court finds the defendant over to Wayne County Third Circuit Court Criminal Division for the proceedings. This arraignment on the information date and time will be March 13th, 2023 at 9:00 a.m. Following the continued.
Thank you, Judge.
Thank you, sir.
Thank you, Judge.
Mr. Kenneth, you still out there?
He is, Your
Can you have him step in?
You need enough money.
At the end of the day, it's
That's 2 cases over.
Which case are you on? Williams?
Yes.
Yeah.
Oh, I know.
No, I said over.
Is that okay?
I said over. He has 2 cases. That's right.
Calling case 2261097 for the state of Michigan versus Desmond Hope.
right here.
Mr. Hogan is charged with count 1 assault with intent to great bodily harm, less than murder or by strangulation. Count 2 malicious destruction of fire or police property. Count 3 domestic violence. Defendant has an additional third offense notice. He also has case 2261096, charged in count 1 assault with intent to great bodily harm, less than murder or by strangulation. Count 2 domestic violence. Defendant has an additional third offense notice. Appearances for the record, please.
Good morning, Your Honor. So I'm assistant on behalf of people, P83923.
And may it please the court, Neighborhood Defender Service in Detroit by Jeffrey Kenneth, P64800 on behalf of Mr. Hogan. Mr. Hogan, please state your name for the record.
Yes, my hope.
There's the date time set for preliminary examination. Are we ready to proceed?
Judge, I don't know. This was not on my docket. I do apologize. I also, as you know, I'm covering it, so I didn't receive even a file for this case. I don't know how it was not listed when this docket was planned. I can see if anyone is here. I don't think it would be because if AP Drain wasn't aware of this, I don't think subpoenas would have been sent out. So one, please. Yeah. Judge, I'm sorry to have to do this, but my request was for an adjournment. I have no idea how this did not appear on our docket. I have a stack of files that I was ready to report on. This was not one of them. It's my understanding that because it's probably not listed, I doubt anyone was even notified of today's date and time.
So this matter was originally scheduled for preliminary examination on February 22nd.
Well, yeah, the most recent one was Wednesday.
Yeah. So
it wasn't APA Drain. It was
Oh,
the young lady that was filling in for her last week.
Yes, I see. It's in family.
Yes.
So I don't know if she's supposed to be covering it.
So I don't recall if witnesses were actually here on the 22nd.
I don't believe we know for sure because we did it earlier than the scheduled time to try to avoid with the weather and everything, to avoid there being people coming down unnecessarily.
So I put it over from the 22nd to the 27th. That's only 5 days. I'm not sure if the witnesses appear on that day. Do we have any notes as to whether or not witnesses appeared on that day? You know, sometimes my officers have to sign and shoot.
I think that was scheduled for 2 or 5. About the prosecutor probably called for
And Your Honor, if they were notified not to come on Wednesday, they would have been notified at that time since we had just reset the new examination. And there's no witnesses here, Judge. If they want to reissue, they can reissue if they get a hold of the complainant. We would ask for it.
Have you tried to reach the complainant's time?
Judge, I mean, I can try now. Like I said, I didn't even know this was on here. I know that's not a valid excuse, and I do apologize for that. I really don't.
Let's see if we can, well, I can't put you guys under the gun by giving such a short term. See if you can reach the complainants now and see what their status is, if they wish to proceed with this matter. They just didn't know about it.
I appreciate that. Thank you. I mean, let's do it right now.
Wayne County Jail, what's your name?
Ramel Walton.
Mr. Walton, your next court date is March 14th at 11:30. That's in person in 36th District Court.
I'm sorry.
Your next court date is March 14th at 11:30. That's in person in 36th District Court.
Do I have a bond or anything, sir?
Your bond is continued. Whatever your bond was, it remains the same.
I was remanded last time.
Then it's remanded this time too. Your bond has been continued.
Yes, sir.
Correct? Mr. Baker.
Yes, Your Honor.
Calhoun?
Yes, Your Honor.
This is case number 2355770. The people of the state of Michigan versus Terrence Calhoun. Count one, assault with intent to do great bodily harm less than murder or by strangulation. Count two, domestic violence, habitual offender, second offense notice.
Appearances for the record, please. Go ahead, Mr. Your appearance, Mr. Vicker.
Oh, I'm sorry, Your Honor. May it please the court, Tyrone Bickert, appearing on behalf of Mr. Calhoun, Terrence Calhoun, who's present via Zoom, Your Honor. Good morning. Your Honor, I apologize. It's a little difficult to hear.
I know you have a lot of notes. Mr. Calhoun, tell me your name for the record. Tell me your name, Mr. Calhoun.
During the breakout room, Your Honor, me and Mr. Calhoun had a little bit of difficulty. I think he's having some trouble with his connection.
That's okay. What's your pleasure, Mr. Vicker?
Your Honor, we're requesting to examine this matter respectfully.
Your Honor, can you hear me now, Your Honor? It was muted.
All right, I hear you. Court will continue the plea of not guilty and set this matter for preliminary examination. House March 15th at 10:30.
March 15th, Your Honor? Yeah.
I'm checking in now, Your Honor. I apologize. March 15th. That's at what time, Your Honor?
10:30.
That should be fine.
10:30?
Yes,
Thank you, Your Honor.
We'll go over the dates and everything.
Okay.
March 15th at 10:30, Your Honor, we're all set?
Yes, sir. Thank you.
Thank you, Your Honor.
Thank you.
You're all
Thank
set,
you,
Mr.
Honor.
Calhoun. Call me at
All
that
right.
number.
Yep. Thank you.
What's your name, sir?
Shandell Bracy, good morning.
What's the last name? Gracie?
Yes, Bracy.
We're just waiting on your attorney, Mr. Gracie. Mr. Kenneth, you ready? Sorry?
You asked if I was ready, Judge.
Yes.
I'm ready with Mr. Hogan. I just don't think he is.
Okay. Oh, that's right. That was, she's calling plaintiffs.
Well, you should have lived with that. Yeah, I learned it now. I learned it. I know, you always have. I've been on the same sometimes, and that's crazy, and I don't know what the status of it is, but it's still in this report, but it's the dirty report, and I've been showing that every, and every time I show that the prosecutor can have I tell you again, the solid case, with another solid case pending, I do our report. Sure, I will. Thank you very much. Thank you. I do, okay, get down. We're at the silence. And GPS 7, no contact is complaining while this man is still pending. Thank you, Judge. No contact, gotta get started. Thank you. Hey, you're on the this 10,000 for 1,000 pairs? 1,000 pairs. Yeah. No contact. I'm just running a little note on the file right here. They are on the bed morning. Yeah, they are. Okay, you know.
Okay, Did you know?
Judge, unfortunately, the phone is going straight to voicemail. My concern is that we've had contact with her. I have dates reaching back from at least when they spoke with her back on 1/17, when last week's court date was set, and prior to last week, when the case was canceled. And so my concern is that the fact that we've had contact with her, I don't want to just have the case be dismissed because I can't reach her at this moment. And again, I recognize that this is not a valid excuse just for me not being aware of the court date. But I feel very, the fact that we have two cases, both assaulted, seeing that they're been based on the court dates. I request one last year, saying that maybe that might be asking too much, but I would like to just make that record just because of the fact that it's not one of these cases where we've never had contact with her. I mean, our advocates have reached out to her. It sounds like the police officer was able to reach her with the first subpoena. We didn't have a subpoena for today's date. Again, I don't know why that is, and so that.
So this case has quite a bit of history. Back on January 27th, the complaining witness appeared late. It dismissed the matter once they appeared and was reissued. Dismissal was set aside. 16. And it was adjourned because that has something to do with you. Mr.
I was unable, I couldn't appear in person.
And then adjourned again on the 22nd because of Mr. Kenneth and or the weather. So it would look as though there is a cooperating witness here. A cooperating witness who wants to proceed in this matter. Given that I've already granted the defense counsel 2 bites at the apple, I can give the people 1. So the court will adjourn the matter, finding good cause for the adjournment. That's due to the court's scheduling, how I set the exam rather soon and to give people enough time to secure the presence of their witness. So I'll take the lead on that. So I'm going to pray that Mr. Kenneth's health and the weather holds up. We'll set this matter for how's March 15th at 11 o'clock? Fine, Judge. Okay.
Thank you, Judge. And I'll make sure that the OIC gets the subpoenas for that 2 days so that the complainant has more than enough time to be aware of the court date.
All right. Thank you very much.
Thank you.
Your Honor, I would ask with the adjournment that obviously attributable for the defense, but none were Mr. Hogan's like requests or issues. We ask the court to consider a reduction in bond to a personal bond for DPS other than Mr. Hogan. Obviously, no contact. The DPS other would ensure that, and I know that he is working and his supervisor has reached out to me about trying to facilitate getting him out so he can return to work. He can stay with family, correct? So that there's no contact, wouldn't be an issue. So, Your Honor, we're just asking the court to consider that personal bond.
Where does he work at?
I work at Jules Property Management.
What do you do there?
I'm a property manager.
How long have you worked there?
I worked there for 4 years.
Judge, what is the current bond set at?
Well, he has 2 cases before the court. That's usually a no-go. His bond on each case is $10,000, 10%. So I'm inclined, given the circumstances, to reduce the bond to a personal bond. I'll make it house arrest, work in court only.
Thank you, Judge.
No contact, sir. You know what I mean by no contact, don't you?
No contact, sir. Thank you.
Judge, did I hear that we had Terrence Calhoun on Zoom earlier?
Yes.
Was that adjourned? I think
Yeah,
that
we
was.
set for exam March 15th at 10:30.
You said that was for exam?
Yes.
Okay, thank you.
Have a good day, everyone.
Thank you, sir. Hello there.
How are you?
I'm good. How are you?
I'm good.
Good. Hi. How are you?
Good.
All right. We got going. This hits.
Yes.
I'll get it.
Gerard Diallo Hicks, calling case 2355445, people of the state of Michigan versus Gerard Diallo Hicks. Defendant charged in count 1 assault with a dangerous weapon, count 2 aggravated domestic violence. Appearances for the record.
And Neighborhood Defender Service by way of Emily Newman, number 85234 on behalf of Nora and Sue standing to my left.
Tell me your name for the record.
Warren.
There's the date, time set for preliminary examination. Here's my prosecutor. Get her some roller skates for Christmas too.
Hi, I was just talking to my husband.
Just call Hicks, appearance for the record, please.
Yes, good morning, Your Honor. Someone will CC on behalf of people, P83923.
Today's the date, time set for exam. Are we ready to proceed?
We are, Judge.
How many witnesses for the meeting?
Judge, just one witness.
All right, ready to call your witness.
Your Honor, the defense did wish to waive the exam. I haven't had a chance to speak to the people this morning. I don't know if they are agreeable to that or not.
Judge, at this time, the people do not agree because I had emailed defense counsel last week with our intention of adding an additional count at exam if, of course, the facts are established, and that's why, because the report doesn't accurately describe this incident, I would like to hold the exam and have our complainant testify and potentially add an 12 extra.
Would you be willing to waive to the added comment to it?
I believe so. Judge, I would still like to hold the exam just to get the factual basis established through a transcript. Thank you.
That was it.
Ma'am, please step forward, give your name and the spelling of your name to the young lady seated over there. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you, ma'am. Please have a seat in the witness box next to me. Speaking to that microphone is going to be to your left. In fact, you can raise it to your, you can hold it in your hands and raise it to your mouth so you can speak directly into that voice. Okay? Okay. You may begin when you're ready.
Thank you. Can you please state your name again for the record?
Trudy Fields.
Thank you, Trudy. And do you know an individual named Jawara, Jawara, Hence, Hence?
I do.
And how do you know him?
He was my boyfriend,
And how long was he your boyfriend for?
about 2.5 years.
You said he was. At some point, did the relationship end?
Yes,
And when was that?
on February 3rd when he stabbed me.
Okay. Did you guys also live together?
No, he has his own apartment.
Okay.
We stayed with each other, but technically resided somewhere else.
Okay, thank you. And do you see Mr. Hens in the courtroom today?
I do.
Can you please identify what he is wearing?
Beige shirt, black one.
Judge made a record request that the witness has identified the defendant as Mr. Hens.
So noted.
Thank you. In honor about February 3rd, the date that you just mentioned, where were you? What location were you at that day?
At my apartment on Greenfield.
Okay, and what is the address?
14590 Greenfield, apartment 343.
And is that in Detroit?
Yes,
In Wayne County?
yes.
And was anyone else with you at your apartment that day?
Yes,
Who was with you?
Jawara.
And what were the two of you guys doing?
We were talking, we were drinking.
Okay, you said you were drinking. Were both of you drinking?
Yes,
And were either of you consuming any other substances?
no,
Were either of you intoxicated?
yes,
Which one or who?
both.
Both. Okay. And what were you drinking?
I was drinking vodka and she was drinking beer.
Okay. And at some point, did you guys have any sort of argument?
We did argue. I really couldn't tell you about what.
Okay. Do you remember anything that was said during the argument?
Aside from the names he always calls me.
Okay, what do you mean by that? What names did he call you?
Dumb, stupid, retarded, white bitch.
Okay, and did your guys' verbal, I guess, interaction turn physical at any point?
Yes.
And what happened?
I don't even remember how it happened, but I know he sat on my chest and choked me, so I was unconscious. And then when I came back to, he was on the floor next to me, and he had a knife over me and said, "You're dying anyway. You want to die tonight?" And took the knife and stabbed me.
Okay, so you said a lot, so we're gonna unpack some of that, okay?
Okay.
First you mentioned that he was sitting on your chest, and I think you said he choked you?
Yes.
Can you describe how he did that specifically?
Like I said, he sat on my chest and took both of his hands, and put them around my neck.
Okay, and when he put his hands around your neck, did he apply pressure?
Yes.
And was that pressure, or did that pressure in any way impede your ability to breathe?
Yes.
Okay, and you mentioned you lost consciousness.
Yes.
Can you describe, the effect that it had on your vision?
Everything like went black.
Okay.
It just went dark.
Do you remember, your body experiencing any other sensations or symptoms as a result of the strangulation?
No,
Okay, and so you mentioned that at some point you came to,
yes,
okay, do you know, do you have any sense of how long you were out for?
I have no idea.
Okay, that's okay. And I'm sorry, I'm gonna take one step back. You mentioned he was, sitting on your chest, so were you guys laying down?
Like I said, I don't remember how, but I was on the ground
Okay.
and that's when he sat on my chest.
And how did your, neck or throat feel after the strangulation?
It was extremely tender, sore.
So you mentioned when you came to, you saw a knife. Tell us more about that. What did the knife look like?
It was maybe about 6 inches long. I'm not sure. I don't remember what color the handle was. I think it's black.
Okay, do you remember what kind of knife it was?
No,
Okay. Did you see where he got the knife from?
no.
And so what is the first thing you remember after coming to?
Like I said, him sitting on the floor next to me was what I woke up to.
Mm-hmm. So I guess afterwards you mentioned he said something to you. What did he say?
He said, you're dying anyway, because I have cancer. He said, you're dying anyway, are you ready to die tonight?
Okay, and what kind of cancer do you have?
Pancreatic and cervical.
And then where did he stab you?
It's under my, left, armpit, my side.
Is there a reason that that's where the injury occurred?
Because when he had the knife over me, when he was about to stab me, I was in the fetal position with my hands covering my head and face.
And as a result from the stabbing, how did you feel?
I hurt.
Okay, were you bleeding?
Oh, yes.
Okay. And what happened afterwards?
I got up and he had said, oh my God, what did I just do? And I grabbed my coat and phone and ran out the door and my keys and waited on the porch for the cops and EMS.
Okay, so at some point did you call 911?
Yeah, when I was in the apartment.
Okay, and when 911 responded, did you speak to them?
They just asked if he was upstairs, in my apartment, and I said yes, as far as I know, unless he went out the back door, I don't know. But as far as that, no. I talked to the detectives next day when they came to the hospital.
Okay, so you went to the hospital?
Yes.
When did you do that?
When EMS came and got me.
Okay, so the EMS came and they took you to the hospital?
Correct.
Which hospital did you go to?
Sinai.
And when you went to Sinai Grace, when you went to Sinai Grace, what were you treated for there?
Puncture wound. I think that's the technical term they use.
Okay, did you notify them of the fact that you were also strangled?
Yes.
Okay, did they do anything specifically for the strangulation?
The doctors?
Yes.
No. No. They put a C-collar on me and I had to have an MRI.
Okay, and that MRI was specifically for the fact that you indicated you were strangled? Okay, and then as for the puncture wound, how did they address that injury, if they did at all?
They cleaned it and they didn't stitch it up. They said because they didn't know where the knife was, if there was infection, they wanted it, if it were to get infected, that they would want it to seep out instead of me going into septic.
Okay. Understood. And other than, of course, the obvious injury of the stab wound, did you have any other bruising, lacerations, anything like that on your body?
I had bruises all on my neck.
And then you mentioned the detective came to the hospital the next day?
Yes,
So how long were you at the hospital for?
2 days.
2 days. After you were discharged, have you had to, or have you been suffering any sort of ongoing problems from your injuries?
Yes.
Like what?
My left arm, it feels like it's, when it falls asleep, when you have the pins and needles, it constantly feels like that, and, I don't have full function of my left hand.
And then initially, did you notify police that you were also strangled?
Yes.
And when did you notify them of that?
When they came to the hospital, actually, when they came the next day.
Okay, when you spoke to the detectives the next
Yes.
day? Okay. And then at what point did you tell them that you were stabbed?
I mean, I told 911 and then when the cops got to the house, I told them.
Okay. And were any photographs taken of your injuries?
Yeah, the detectives took pictures of my neck.
And that was at the hospital or somewhere else?
Yes.
Judge, I have no further questions. Thank you.
Cross-examine.
Good morning, Ms. Kenneth. I just have a few questions, okay? You said you spoke to the police on February 4th, the next day, right?
Correct.
And do you remember if at that time you signed a statement saying you did not wish to go forward with the charges?
She asked me, the detective asked me if I wanted to press charges, and I honestly was high as a kite from all the pain medication. I said, leave me your card and I'll call you and let you know.
So if you signed anything that day, you would have been high on the pain medications?
Yes.
So you do wish to go forward with charges?
Yes.
You said you were drinking that evening on the 3rd?
Correct.
And that Mr. Hens was drinking as well?
Correct.
Do you remember, and you said he was drinking beer?
Mm-hmm.
Do you remember about how many beers he had to drink?
Throughout the day, probably 8 to 10.
And you were drinking vodka?
Correct.
Do you remember how much vodka you would have?
Oh, I had 3 half pints throughout the day.
And do you and Mr. Hens tend to drink together?
Yes.
So this was not an abnormal amount of alcohol?
No.
Or not? And so you both tend to drink together?
Yes.
And was Mr. Hens, he was intoxicated, correct?
Correct.
Would you say he was more intoxicated than he often gets, or was it?
Yes.
It was. Do you recall him passing out at any point from the alcohol?
Did he? No.
Not that you saw,
No, not that I saw.
but he was more intoxicated.
Yes.
Does he have a drinking problem?
Yes.
Would you say you have a drinking problem?
Yes and no at the same time. I mean, I don't have to drink. I don't go through withdrawals or anything like that. But I just do it, yeah, because I want to.
So by problem, you would say you do drink a lot, I guess.
That I do, or?
I'm sorry, I'm just trying to clarify. So you cannot drink and not feel bad is what you're saying, but you do
Right.
drink.
Yeah.
Okay. That's all. Thank you very much.
Any redirect?
No, Judge, thank you.
People, what is the charge that you may seek to add?
Judge, we would like to add assault, with intent to do great bodily harm or by strangulation, which I believe is NCL 750.84. I remember off the top of my head.
In light of that, Ms. New, do you have any other questions? All right, thank you, ma'am. You may step. Any other witnesses for the people?
No, Judge, thank you.
Any witnesses for the defense?
Mayor.
People.
Judge, at this time, we believe that we have established probable cause for both the new added count for assault by strangulation, as well as what would now be count 2, the assault with a dangerous weapon, and then of course, the domestic violence aggravated was carried over as a misdemeanor. Based on the testimony, the complainant indicated that she was strangled to the point of unconsciousness. When she came to, the defendant not only threatened her with a knife, but then stabbed her in her, I believe it was her left armpit, she has now been suffering ongoing problems because of that, and therefore we believe that we have met the elements for all of the counts, and we would request that these counts be found over to the circuit court.
Ms. New?
Just note our objection to our record.
All right, the court after hearing the testimony of Ms. Feeney is satisfied that people have met their burden of probable cause as relates to the original charges of the complaint, one as well as the added charge of assault, typically great bodily harm, less than murder or by strangulation. The court finding those charges were committed in the city of Detroit, the court finding probable cause to believe this defendant committed them, will bind the defendant over to Wayne County Third Circuit Court, Criminal Division for further proceedings. Are there any issues as to bond?
I do not believe so, Judge.
All right, bond will be continued, which would make his arraignment date March 13, 2023 at 9:00 a.m. You said that's 750-84?
784.
Thank you.
Thank you.
Okay. Raise my hand. Okay.
Mr. Reed. Mr. Reed there? What's up, Brad? Unmute yourself, I can't hear you.
What's going on, Mob? He right here.
All right.
Good morning, Your Honor. Yes.
Good morning. So your client's been waiting on you all morning?
Yes, but you know, we had contacted the assignment services, and we had declined this particular assignment. You know, we're not qualified per se. You know, we do a tier 4, and this is not a tier 4 case, so we were asking it to be reassigned. I was surprised when I got the call from you guys, but I mean, I want to make sure it's taken care of.
All right.
Do they still have house counsel and people like that that are available?
No, we got a call over.
Okay. We thought that they reassigned it. They said they were going to, but I don't know how that fell through the cracks, but I apologize to the court.
Okay, nobody told us, but thank you.
No, thank you. I appreciate your clerk's efficiency in calling us.
when you get back, when you call the first.
Take back tomorrow.
What time?
I'm just going to the bathroom.
Everybody's here for the 11 o'clock.
You can have them step in.
He has that.
I hope they say one. Oh, yes. So our people, now we don't have paper files anymore, so I don't always have the most. Let me look online. See if I, because I don't, I think this is just like a chip copy. That's the fun. Well, he's here.
Yeah. That's.
Oh, okay. Let's say that you know the statement that I'm asking, or you're just inquiring it. Okay. I don't see it. Okay. Just gonna go, talk to you.
Who was the word? Who was this letter going to?
I believe it's his job.
His job. Okay. That's all I was wondering.
The assignment first.
No, not you. I'm sorry. They had me do this, letter for.
We have Ms. White step back. Oh, there she is. Ready, Ms. White?
Good morning, how are you, Judge?
I'm good. How you doing?
Good, good, good.
How you been feeling these days?
Been feeling good. A lot of nutrition and water. A lot of good nutrition and good hydration.
Okay, great.
How about you?
I'm doing very good.
Good, 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 good.
Got Mr. D. Bardelli.
Yeah,
D. Bardelli.
we're ready.
Where's my process?
Yeah.
And I was going on with my heart. So
Yeah, she's asking for just one more. Let me tell her yes or no.
I'm just from the school of thought that your first conversation with your claim should be right before they walk in the court. That's just me. Calling case 2355430, people of the state of Michigan versus Bianca Denise D. Bardelli. Defendant is charged in count one domestic violence, third offense notice. Defendant has a habitual offender, fourth offense notice. Appearances for the record, please.
Good morning, Your Honor. Sean Mulcahy on behalf of people, P83923. And I realize I'm probably late now, but I never spelled my name for the clerk. It's my last name is spelled Movsisyan.
And good morning, Your Honor. Rita White on behalf of, please state your name loudly for the record, ma'am.
Bianca D. Bardelli.
This date time set for preliminary examination. Are you ready to proceed?
We are, Judge. Our complainant is present.
How many witnesses for the people?
Just one.
Ready to call your witness?
Yes, Judge.
Please do.
Thank you. The people called Eddie, last name DeBardeleben.
Sir, please step forward. Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. Please have a seat. Witness stand. That microphone to your left, hold that in your hands and hold the mic up to your mouth. Speak directly into that voice. You may begin when you're ready.
Thank you. Hello again, can you please state your name for the record?
My name is Eddie DeBartoletta.
Thank you. I am just gonna ask that you speak up just to make sure that everything that you state is, picked up by the record. Do you know an individual named Bianca?
Yes,
And how do you know her?
we're married, that's my wife.
How long have you been married for?
We've been married for 5 years.
And do you have any children in common?
Yes, we have 2 children,
And what are their ages?
10-year-old twins, boy and girl.
Did you at some point also reside together?
Yes,
And what was that location that you lived together?
13911 Bramwell Street, Detroit, Michigan.
And that's in Wayne County, correct?
Yes,
Do you see Bianca in the courtroom today?
yes.
And can you please identify what she is wearing?
She has on a cream shirt.
Judge, may the record reflect that the witness has identified, the defendant as Bianca, and I'm not gonna pronounce the last name correctly.
DeBartoletta.
Yes, thank you.
So noted.
Thank you, Judge. Were the two of you guys together on or about February 1st, 2023?
Yes.
And what were you two doing that day?
I was just coming home from my grandson's birthday party, and I was sitting down helping my daughter with her homework. She was upset about me taking our kids to my grandson's birthday party, and she was.
Your Honor, I'm gonna have to ask for clarification or object to the she. I would ask for clarification who is she.
Bianca, my wife, she was upset about me taking our children to my grandson's birthday party to Chuck E. Cheese, and she was like, you know, she was upset. She was arguing. I mean, she was cussing me out.
So I'm just gonna stop right there just so we can break down some of what you mentioned. You said you went to your grandson's birthday party. Do you have a child, outside of your relationship with Bianca?
Yes, I have a 20-year-old daughter.
Okay, and that 20-year-old daughter is the grandson that you're referring, or
Yeah,
has a child?
Yes.
Okay, and you stated, was that earlier in the day, or at what point did you take your children to this event?
It was probably like 5 o'clock, 6.
Okay. And then you mentioned that once you were home, Bianca was upset. Can you describe how what her demeanor was and led you to believe she was upset?
She was while we were there at the Chuck E. Cheese, she was sending me threatening text messages saying she was gonna harm me, knock my head off, pack me up. I don't know what that means, but you know, she was threatening me, and you know, I was helping my daughter with her homework. She came up to me, you know, saying threatening stuff, pointing her finger in my face. I'm like, you know, I'm trying to help our daughter with our homework. Could you know, please get away, you know, chill out. And she just punched me in my face. So I got out and I called 911.
Okay, so where were you when the assault happened?
I was in our dining room.
Were you sitting down or standing up?
I was sitting down.
And how did she punch you in the face?
She just clocked me in my face like I don't know what hand it was, but she just hit me in my face, in my eye.
Okay, do you recall which eye,
It was my right eye.
Did she say anything at that point to you?
Yes, she still was threatening me and threatening me with all type of cuss words, just wild.
So when you say threatening, and if you can, do you remember anything specifically? Because that word encompasses a lot. So do you know of, or do you recall anything specific that she was saying to you?
Just saying saying she's gonna F me up and saying she's gonna F me up and, all that type of stuff.
Were you, what did you do after she punched you in the face?
I called 911. I walked away and called 911. Her son, was restraining her. She has a 20-year-old son that lives with us. He was restraining her. So, I called 911 and, I just went outside.
Okay, was that, who is the son that was present?
His name is Larry Wells.
Did he actually witness the assault?
Yes,
And then you mentioned you were helping your daughter. Was she also present when the assault occurred?
yes, both of my children was present. That's Eddie Jr., the part of Laban, and, Aubrey, the part of Laban. They both were present, 10 years old.
Okay. And once the police arrived, what happened after that?
They told, I explained to the, officers what was going on. I was standing outside, I explained to them what was going on. They just went in there, they were in there for about 30 minutes and then they walked her out with handcuffs.
Okay. And then you mentioned prior to that she was sending you threatening text messages. Do you, I know you mentioned what one of them said, but I don't recall what it was. Do you mind stating that again, what she was saying in those text messages?
Saying, when I get home, she's gonna knock my head off, saying she's gonna pack me up. That's what I can recall. I have the text, I don't have my phone, I don't have them verbatim.
No, that's okay. And how did you feel when she assaulted you?
It's like demeaning.
Were you concerned for your safety in any way?
Yes.
And how is that?
For prior circumstances that happened before with weapons, I don't know.
Okay. Sorry, one moment, please. Oh, do you know whether or not Bianca was drinking that day? Or did you actually see her consume any alcohol?
I didn't see her consume any alcohol.
Okay. Did she appear intoxicated to you?
Yes.
I'm gonna have to object to speculation in terms of a peer. That's no
We have a better
verification.
foundation.
Okay, thank you. Did you, you indicated that you did not see her consume any alcohol. Could you smell any alcohol on her?
No, I couldn't smell any alcohol.
Okay, were there any indications to you, based on her demeanor or her actions that led you to appear that she may have been intoxicated?
Just the erratic behavior and, just the erratic behavior.
Okay.
How long were you married?
Been married for 5 years.
5 years.
We've been
You
together
dated
for
before,
15.
I imagine you dated before you got married.
Yes, we've been together for 15 years, about 14, 15
In those
years.
15 years, have you ever seen her drunk before?
Yes,
And you saw her drunk on those other occasions. Did you actually see her drinking?
yes,
All right. Was the behavior that she exhibited on the day in question like the behavior that she exhibited when she was drunk?
yes.
Thank you, George. And did you have to get any sort of medical attention for the injury to your eye?
No.
Okay. I have no further questions. Thank you.
Cross-examined.
Okay, so you had testified that you'd been married to, your Miss DeBarda Laban for 5 years,
Yes.
together for 15 years.
About 14, 15 years. It's been a long time.
Okay, so you had the 10-year-old twins before you were married, correct?
Yes, ma'am.
Okay, and now when you indicated on February 1st, 2023, you had called 911, correct?
Yes.
How long did it take for the police to respond to the home?
They were there like, about 10 minutes.
Okay, and now when they came, did they come inside of the home or
No.
did you meet with them outside?
I met with them outside, and they told me to wait outside, they knocked on the door, and then, they let them in. Well, I think Bianca let them in.
Okay, so Bianca, stayed at the home while, after you called 911?
Yes,
Okay, and now, how large is the home? Is it a home, what type of, is it an apartment?
it's a 3-bedroom home.
Okay. Probably approximately how many square feet?
I'm not sure, it's like a ranch style house.
Okay. When the police came to the home, where was Bianca in the home?
I have no idea where she was at when the police came, because I was outside.
When you spoke with the police, did they advise you or inform you as to whether they had any type of body worn cameras on them?
No,
Were you able to view any cameras
no,
coming out of their forehead or?
no,
Okay. And Bianca wasn't with you when you opened the door for the police, correct?
no.
Okay. And now, did you, at any point in time, provide a written statement to the police regarding these allegations?
I don't think so.
Okay. Did the police inform you as to whether they were recording your statement?
No.
Okay. Now, you had testified that you had been, hit in the head, hit in the eye, correct?
Yes.
Okay. And was it just one swing?
Yeah, it was one swing, but previous to that, she poked me in her, she was pointing in my face and, pointing in my head.
When you say previous to that, was that on the same date of February 1st, 2023?
Yes.
At the home?
Yeah, just like 2 seconds before she hit me in the fist.
Okay. And where was the hit? Was it at the table? You indicated that you were at the table, correct?
Yes, it was at the table.
In the kitchen?
In the dining room.
Okay, and who was at the table? Who was sitting at the table with you?
My daughter.
And would that be your 20-year-old?
No, that's my 10-year-old.
Where was your other twin at the time?
I think he was in his room.
Who else was in that dining room area? Who outside was sitting at the table was?
When it first started, it was just, I think it was just me and my daughter. My son might have been coming in and out of the dining room from his room, but I don't know for sure. But after it happened, her son came and restrained her, held her back.
Okay, so when you say you think, you're not very.
Yeah, for sure, he was there and holding her back, right after she, hit me in my eye. She was yelling and screaming, so, he came upstairs.
Okay.
He lives in the basement, so he came upstairs to see what was going on.
Okay, so you had thought, like, in terms of who was actually at the table or in that room when this alleged punch?
It was my daughter. My daughter certainly was there because I was helping her with her homework, 10-year-old.
Okay. You indicated you did not suffer any injuries?
No, I didn't suffer any injuries.
Did you seek medical attention at all?
No.
And you had indicated this, you had received text messages leading up to this encounter with Bianca, correct?
Yes.
And you indicated you had saved these, did you save these text messages?
Yes.
Did you provide them to the prosecutor's office?
No.
Is there a reason why not?
I didn't ask me for one.
Is it fair to say that, were you in any way, shape, or form, did you ingest any type of alcoholic beverages?
No.
Any drugs?
No.
Do you have any convictions for theft or dishonesty?
No.
Isn't it fair to say that Ms. Bartoleben had a bag and came to the table and just pushed it at you?
A bag?
Yes, like a Wendy's bag or?
No.
And by at the time that Mr. Bianca had come to the home, how long was she at the home before this alleged punch occurred? How long was she?
She was there. Earlier in the day, and our children got home from school like 3:00, and then me and the children left out like around 4 to go to Chuck E. Cheese.
Okay, so where was Bianca, if you know? Was she in the house or outside the house when the text messages were sent back and forth?
I don't know, because I was at Chuck E. Cheese. But she was sending the text messages.
What date were these text messages sent?
The same day of the incident.
How many hours before the incident?
Probably from like around 6:30 all the way until 9. She was sending several messages.
And did you respond back to Ms. Bianca?
No.
And you had testified, you had made gave some testimony about, my client not liking your daughter.
Yes.
Okay. And was your daughter, had your daughter been living at the home?
No. It was her son's 2-year-old. He just turned 2, so I just took her to Chuck E. Cheese with my kids.
I have nothing further at this moment.
Any redirect?
No, Judge, thank you.
For this hostility that was shown to you was because we believe you went to party at Chuck E. Cheese with your daughter?
That was what the argument was that day, but just previously, there's been incidents, you know, and, it's been ongoing since November. It's been destruction of broken TVs and around the house. It's been
I'm
wild.
going to object to the relevance of this testimony.
So, if what you say is true, sir, I applaud you by leaving and calling police. You absolutely did the right thing. Any other questions for this witness?
No, Judge, no, Your Honor.
Thank you, sir. You missed that.
Thank you.
Any other witnesses for the people?
No, Judge.
Any witnesses for the defense?
No, Your Honor.
Judge, the count that we have here is the count 1 domestic violence third offense. So the elements are for like what would be considered misdemeanor domestic violence. I believe that the credible testimony showed that the defendant did assault the complainant by punching him in the face once, specifically in the eye, and that did cause or that was unwanted contact, and because of that, we feel that we have met the elements for domestic violence. Oh, and that it put someone or the complainant in fear of another battery, of course, did occur, and therefore we request that this count 1 be found over to the circuit court.
So this is always confusing in that for domestic violence, of course, you don't have to put in proofs on because it's misdemeanor. In this case, because of the enhancement, it makes it a felony because it's the third offense notice.
Correct.
There's some controversy as to whether you have to establish the 2 prior incidents for it to be a domestic violence third.
Judge, it's my understanding that for exam purposes, we do not, because that third offense only comes in at sentencing, and so at sentencing is when we have to.
Yeah, that's one
exactly.
school of thought.
Yes, and that's how I handled my domestic violence third offense exams. So I don't actually, I mean, we have, of course, what's stated here as the prior instances, and we have, or we're able to verify that through her criminal history, but I do not have certified copies of that. I've never had to introduce those at exam in the past. Again, because it's my understanding that that would need to be introduced at sentencing if in fact it is in to the felony.
So that is one school of thought, that it is an enhancement and it's to be addressed at sentencing. Not much like habitual was. And then there's another school of thought that says that if this is a domestic violence third, then you have to establish that there was a first and second, and that this would be the third in order for it to be bound over. As a domestic violence third offense notice. And that if you don't establish that, you only establish domestic violence one, and it will be a misdemeanor, you will go to the misdemeanor court. Right?
Yes, Your Honor, I would, if this is a matter, this is the issue. She's charged with domestic violence third offense. With that term right there, there does have to be proof that my client has 2 prior convictions. However, there is also a third offense notice, which the notice is what is basically it's a habitual. However, it's converted into a third offense notice based on her obtaining the domestic violence conviction from the past. However, given the fact this is under 750.812, the prosecutor has to show by reasonable probable cause that my client did indeed have 2 prior convictions for it to rise up to the level of third offense. And that would have to be through a certified, some type of proof, because you can't just come and charge a person with third offense and have an exam held with no proof placed on the record that she indeed has 2 prior domestic violence convictions formally. If that was the case, anyone could come around and say domestic violence third offense without proof, and they're bound over to circuit court on a felony, which there was never any proof provided by probable cause that my client has indeed had 2 prior convictions.
Yeah,
So
I think what differentiates this from your ordinary habitual, and even in this information, she has a third offense notice, but she's also charged as a habitual offender, 4th offense notice. So that 4th offense notice would be the enhancement. The third offense notice, I believe, is part of your proofs that you have to show.
Judge, if I may, I think I would disagree respectfully, and I only say that because for the purpose of an exam is to show the elements of a crime. So the domestic violence elements do not change between.
No, but see, the element of this crime though is that she had to have 2 prior offenses in order for it to be a felony.
Yes, and the fact that all she needs is notice though. I think the statute just says notice of the fact that she is charged as a habitual third. And the felony information is that notice. The difference between this and let's say a felon in possession or an aggravated stalking that do require certified copies is that those elements are those aspects are part of the elements of the charged offense. This is not part of the element of the charged offense that we would have to prove. Like when you search in any sort of criminal jury instruction, all it requires is to show that an assault occurred and whatever the elements are for domestic violence, because the jury is not making the determination as to whether or not she's a third offender as an element when they're hearing the case. They're making a determination as to if an assault occurred, and then the judge would then ask us to present our evidence as to, okay, what makes this a third offense? And that's at the time when the proofs are shown, but it's not an element which a jury would consider in their deliberation.
You're correct. I believe I'm going to take that position as well. And the third offense notice, first couple of words do say take notice that the defendant was previously convicted of assaulting or assaulting, battering her spouse, former spouse, et cetera, et cetera. So I think the turning point here is what does our jury instruction say as it relates to domestic violence third offense notice? Does it make that one of the elements? And I don't believe that it does. All the people have to show is that domestic violence occurred, and then at sentencing, if the defendant is convicted, the third offense notice is the enhancement. So the court, after hearing the testimony of Eddie Burrow, Deeper 11, is satisfied that people have met their burden of probable cause as it relates to the charges contained in the complaint form. The court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this defendant will be bound over to Wayne County Third Circuit Court Criminal Division for the proceedings. Are there any issues as to how?
Your Honor, I thought I was under the understanding that you were just addressing the notice, but I did have arguments.
Oh, I'm sorry.
It's okay.
I didn't know what you did. Go ahead.
Your Honor, overall, this is a question of fact. We understand the court's burden. However, with the testimony that the person, the complainant provided, is that there was no medical attention, plus there was no witness statement.
It doesn't have to be.
So, Your Honor, we're just arguing the fact that, given the fact that it's his word, but we don't believe his word alone, given the fact that there's no evidence or testimony other than what he believes or thinks that my client was under the influence of alcohol. There's no evidence of any type of pictures of any type of injury or any issue that would corroborate his story, so we're.
This sworn testimony is evidence. And the fact that there was no significant injury doesn't matter, doesn't have to be. All that's required here is that there be an assault. Injury is not one of the elements of the offense charge. So that being said, again, the court is satisfied with people that their burden of probable cause as it relates to the charges contained in the complaint warrant. The court finds those charges were committed in the city of Detroit. The court finds probable cause to be disciplined committed. Again, are there any issues as to that?
Your Honor, we're asking that my client's bond remain as is. She's been compliant since she was arraigned. There's been no contact, no issues. She's maintained her separation from the complainant. However, she does have the twins that are 10-year-old minors. I know this isn't a family court, but we're asking that she be allowed to have at least no assault contact with her twins with a third party standby.
I'm not getting in the middle of that. I'll let you guys handle that. Are there any issues as to bond?
No, Judge, there are not.
All right, that being said, the court will bind the matter over to Third Circuit Court Criminal Division for further proceedings. Her arraignment on the information date and time will be March 13th, 2023 at 9 o'clock a.m.
Thank you.
So you want they're supposed to give someone for place.
I think you just came in, Mr. Schloss. Mr. Schloss, good morning. Mr. Schloss?
Yes, Judge, how are you?
I'm good, sir. How are you doing today?
Good. I'm hearing rumors that you can use me.
Yes, I can. You always fill in the pinch for me. You're here for Mr. Bracy?
Shondell Bracy?
Yes, that would be him. Okay, we're ready to call.
Case number 22609193. The people of the state of Michigan versus Shondell Bracy. Count 1, home invasion, first degree. Count 2, weapons, firearm. Count 3, assault with intent to do great bodily harm, less than murder or by strangulation. Count 4, assault with intent to do great bodily harm, less than murder or strangulation. Count 5, assault with intent to do great bodily harm, less than murder or by strangulation. Count 6, weapons, firearms. Count 7, assault with a dangerous weapon. Count 8, weapons, felony, firearms, second offense notice. Count 9, weapons, firearms, second offense notice. Count 10, weapons, felony, firearms, second offense notice. Count 11, weapons, felony, firearm, second offense notice. Count 12, weapons, felony, firearms, second offense notice. Count 13, weapons, felony, firearms, second offense notice. Count 14, weapons, felony, firearms, second offense notice. Habitual offender, fourth offense notice.
Appearances for the record, please.
Judge, I will step in. This is not our case, though. I just looked it up. It's in the general warrants division. It does not look like a domestic violence case.
We're gonna send that to whoever it's supposed to go to.
Are you saying that it does not belong in your court, Judge?
Yes, sir. Doesn't meet the criteria. It's not a homicide, a domestic violence, a sexual assault, elder abuse, or child abuse. It's not mine.
All right. However you want to handle it.
Let me make useful use of your time and put you in a breakout room with your client so you can at least introduce yourself to him.
Very good, thank you.
Find out where you're supposed to be, okay?
Okay.
Go ahead and join the breakout room. Okay, do we have people ready on Young?
Which case, Judge?
Young, Johnny Young? Oh, we did that.
Oh,
No,
we did that one
already.
Judge. That was adjourned.
So we're down to 12.
Yep.
He's downstairs in custody. We're waiting on his attorney to show up, Judge.
Okay.
Thank you.
Thank you. So I don't know how long it'll take her to do this.
Got some for the sign. I think that did it right. Wait.
They said it would, then it's supposed to stop and then start.
It's the temperature up there.
Wait. You have to, I gotta figure it out. Thanks though. I got, one of them ready now. I only saw the one, right? That was for Hope.
Yeah, yeah, we got.
Yeah, I got his mix ready.
Okay. That's downtime. I have to take those and take them down.
I gotta wait for.
Oh, gotcha. How you doing, sir? Good. We checking in on Mr. Martin.
I'm Mr. Martin.
All right. Yep. I'll call for
Brown.
And we'll be ready on Mr. Bracy when you are.
Okay.
I just called down there, but I had called her. She said she was gonna reach out to see why I'm here to. I actually called like 4 people downstairs, nobody answered.
No, not her. It's out, yeah, out. Yeah, I think she's the one.
Yes, already did.
Good morning.
Hey.
Hey. You all right?
Oh, yeah. No, I know when you talk.
How you feeling today?
I work in mysterious way. It's next to me in church, had a whole conversation. And then it's a. He said, what do you do? I said, I work from home. He said, young lady that you make in your car. And I said, I'm gonna see. Yeah, he said in traffic or something. He's like, what you do? Thank you. Okay, you been there, remember that a long time? Okay. Did you good? My pastor, he young, but he be on fire. He only like 45. He good this week?
Thanks for asking.
How are you? Good, I haven't seen you in a while. I know. Oh, shit. I'm so happy. I'm so happy.
Oh, yeah, that's back in here. Are you still tomorrow?
I'm sorry.
You still celebrating?
Oh, yeah.
Okay.
Absolutely.
Oh, I just saw her in Oh, are they?
Yeah, I'm good. You gotta put the line on. Ms. Brown, you know, I know they call it taking one down.
No, no, it's just, shoot.
Should. Nope. Hey, you got bring Brown up to 2:30?
How are you today?
Good.
Good. So, yes, and remind me.
Carrie. Acting like this the first call.
So our.
I did call.
Oh, okay, perfect. I also have, I am sorry, I only need one copy. I have the certified record of conviction. Do you need a copy of that or do you want just-
Can they take a picture down when they come up?
Yes, of course, let me. The certification is on the wax.
Okay.
Yeah, of course. Okay. No, it'll just be for, yeah, for grammar school, but it's not. Yeah, okay, thank you. And even.
Oh, no.
Okay. Oh, wonderful. Okay.
Hey. Really? So, somewhere on the track.
Okay, it's going to Judge.
Okay, Mr. Schlaf. It's going to Judge Leah Sabri.
And have we a date?
I'm gonna have you go over there now so she can give you a date.
Oh, okay.
All right, Wayne County Jail.
Yes, yes.
Can I get the deputy, sir? Tell the deputy.
Excuse me, deputy. Want to talk to you.
Yes, sir.
We're switching courtrooms. This is going to another judge. This is going to Judge Sabri
Today, sir, or?
Yes.
today.
Yes, sir. We'll get over there.
All right, thank you so much.
No
All
problem.
right, I'll meet you over there.
All right. Ready on Brownlee?
Yeah.
Calling case 2355355. People of the state of Michigan versus Deshaun Cornelius Brown. Defendant is charged in count 1, weapons, firearms, possession by felon. Count 2, assault with a dangerous weapon. Count 3, felony firearm, second offense notice. Count 4, felony firearm, second offense notice. And count 5, domestic violence. Defendant has an official offender, fourth offense notice. Appearances for the record, please.
Good afternoon, Your Honor. Someone help CC on behalf of the people, P8392.
And good afternoon, Your Honor. Neighborhood Defender Service of Detroit, Kerry Martin, P84592, appearing on behalf of Mr. Deshaun Brownlee in court today. Mr. Brownlee, please state your full name for the record. Deshaun Brownlee.
Today is the date and time set for preliminary examination. Are we ready to proceed?
We are, Judge.
How many witnesses will we?
One.
Ready to call your witness?
I am, yes, Judge.
Please do.
Thank you. Judge, the people call Jamelia Ramsey, that's Jameela, last name Ramsey, Ramsey.
I knew on the day that I scheduled my witnesses would actually show up.
That's why I had a-
Day would be dismissal after dismissal after dismissal.
Yeah, I got to call most of, I think, all of my cases on Friday and made contact with them. Judge, I do also, I don't know how Your Honor likes to handle this, but we do have a certified copy of the prior felony conviction for the basis of some of these charges. I did show defense counsel the certified copy. If I may approach to, I don't know if you need to see it as well.
Do you have any objection to it?
No objection.
We'll admit that as People's Proposed Exhibit 1, as People's Exhibit 1.
Thank you, Judge.
Young lady, please give your name and spelling of your name to the lady seated there. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please have a seat in the witness box next to me. Maybe, when you're ready.
Thank you. Hi, can you state your name again for the record?
Jimmy Lauren.
Okay, thank you, Jamila. I'm just gonna ask you a few questions. If you need to take a second, just let me know, okay?
Yes.
Okay. Do you know an individual named Deshaun Brownlee?
Yes.
And how do you know him?
My boyfriend.
Okay, and how long were you in a dating relationship for?
Not long, long enough.
Okay, would you say a couple months or longer?
Couple months.
Okay, and did you guys also reside together?
Yes.
Okay, and where did you reside?
In his brother's house.
In his brother's house? And who is, when you say his brother, is that Deshaun?
Richard.
Richard is Deshaun's brother? Okay, and where did Richard live? Okay,
I'm sorry, I didn't hear you.
But that's the name of the street.
Okay.
if I said 5008 Scotton, Scotten, does that sound familiar to you?
Yes.
Okay, and is that in Detroit, Michigan? Wayne County?
Yes.
Okay. Were you at that location on December 28th, 2022?
Yes.
And who was with you?
Sean.
Okay, was his brother there?
Yes.
Okay, and I'm sorry, can you give me the brother's full name?
Richard. I don't know his full name.
Okay. And what were you and Deshaun doing on December 28th?
And the music, talking. That normal day. He went through my phone, accusing me of cheating, talking to my cousin, my mama best friend. I guess from there, he just blew up.
Okay, so I'm just gonna stop you right there. Before we go further, do you see Deshaun in the courtroom today?
Yes.
Okay, I'm sorry, I'm just gonna ask for you to identify either where he is or what he's wearing. You might need to stand, okay.
Okay.
Judge, may the record reflect that the witness has identified the defendant, Deshaun Brownlee.
So noted.
Thank you. And you mentioned that on that day he blew up, I believe was the word you used. Can you describe what happened? What did he do?
With my phone. So that wasn't going home. He was gonna offer me him. That's when he popped me with the pistol. That's in my lip.
Okay, so you said he popped you with a pistol. What do you mean by that?
A gun.
Okay, did you see where he got the gun from?
No.
Do you remember what the gun looked like?
Oh, it was silver.
Okay. And what part of your body did the gun make contact with?
On the side of my face, my mouth, on top of my eye.
And did he, other than assaulting you with the pistol, did he harm you in any other way?
No. Busting my lip.
And how did he bust your lip?
With his hand.
Can you describe how that happened though? Was it,
With his fist.
and did he say anything to you when that happened?
Yes.
What did he say?
Oh, yeah.
I'm sorry, can you repeat that?
He was gonna kill me, you know. He didn't want me to leave prior that day.
Were you eventually able to leave?
Yeah, eventually.
Okay, when did you leave?
He dropped me off.
Where did he drop you off?
To my grandma's house.
Okay. Prior to you being dropped off, did you contact anyone about what happened to you?
Yes, my grandma.
Okay.
That's how we made the police report.
Okay. At the time the incident happened, did you contact or were you able to contact the police?
No.
Okay. At what point did you contact the police?
I called my grandma. We went to the police station that day.
Okay. And then at that point, did you disclose to the police what happened to you?
Yes.
And at that point, you said, was it that day or was it the next day?
It was that day.
And did you have any injuries from the assault?
Yeah, the busted lip, scratches, a gash on the side of my eye, and my hair was pulled.
Do you still have the mark on your face next to your eye?
Yes.
And you said your hair was pulled? When did that happen?
You was in the car.
When you were in the car? Was that on your way to your grandmother's?
Yes.
Did he do anything else to you in the vehicle?
Just hit me as if I was nothing.
And how did you feel when this was happening?
Scared. Thought my life was gonna go. Never thought it would be something like this. First experience. Never been beat on. Just when somebody fought to get trust. Was around his family. They lived in that family. Just that day he lost it.
You need to take a second, or are you okay?
Fine.
I have no further questions for this witness, thank you.
Cross-examine.
I have a moment to speak with my client. Ms. Ramsey, go ahead. I have some questions. So this incident you're describing, you say this happened, told the police this happened around 6 p.m. on December 28th. And you had been hanging out with Mr. Brownlee that day.
Yes.
For about how long have you been hanging out?
What do you mean, far as dating?
I meant the day, how
We
long?
was together all day that day.
You were together all day that day. And had you been at his brother's house the whole day?
Yes.
And you'd spent time there previously?
Yes.
You said you were living there?
I was there, like not living, but I was there.
Spent a lot of time.
Yes.
So you got in an argument that led up to it becoming physical.
Yes.
It started as a verbal argument. In that verbal argument, did he say he didn't want to be in a relationship with you anymore?
He accused me of cheating with my cousin. It was not, no, I wanted to not be in a relationship. We was with each other the whole day. He went through my phone and accusing me of talking to my cousin. And that's how artists stimulate. Oh, you cheating, oh, you talking to niggas, you doing this. I'm not cheating with you if I'm around you every day. What cheating am I doing? If I'm spending time with you every day.
Thank you. And so you say that the first point of contact that he made was him hitting you in the face with his hand?
Yes.
With a closed fist, you said? Yes. I want you to describe the seconds leading up to that, where you and him were positioned in that closed hand strike happened.
In the car. Right. We went this face shot. And he told me I'm gonna go home when he feel like taking me home. He took a shower and I'm waiting. He told me I'm gonna take you home and tell my family I got jumped and they off.
Now, So the first time he hit you this day was when you were in the car,
Yes.
and this was around 6 p.m., as you said? And where were you driving?
He was driving around.
He was in the driver's seat, you were in the passenger seat,
Yes,
just driving around the area of his brother's house.
yes,
And in that car, is the punch that you described, is that the only contact that happened in the car?
kept hitting inside my Facebook to this,
Why
he said he was gonna kill me.
So the hitting with the gun that you described, that took place in the car as well?
Yes.
Had you been in his car before?
Yes.
And that was Mr. Brownlee's car that you were in?
Yes, that's in the car.
And so you said you did not see where the gun came from?
No.
So did you, let me ask, the seconds leading up to being hit with the gun, describe those seconds. Was it in the middle of a verbal argument with him?
He was angry and it making me get my stuff on. I didn't know where he wanted it from. And that's when he hit me. And he was gonna kill me.
So he pulled the gun out from somewhere in the car, as far as you could tell.
It was in the house. That's when we got in the car, because he said, get your stuff home, I'll take you home. And Austin landed in the house, I was already still bleeding in the car. Face, everything was bleeding, we was at his brother Richard's house. And that's when he pulled the gun out.
Thank you, Ms. Ramsey. So I just want to be perfectly clear. It's important that we get the timeline correct. So he pulled out the gun for the first time. Was it in the house or in the car?
In the house.
Was that before so you say that he punched you for the first time?
Yes.
So your version of events is that you were in the house. He produced a gun from you don't know where.
No.
He hit you with that gun in the house.
And that's when I started sleeping on the side.
Then you went into the car with him.
Because he said he was gonna drop me off. But at that time I didn't know. And my grandma said, why didn't call? Because I was scared for my life.
And did you still see the gun when you were in the car?
I couldn't tell because I was bleeding, so I was worried about blood everywhere. But I know he had it with him still.
You knew he had the gun with him still, but you don't believe you ever saw it in the car?
Yes.
About how long at that point were you driving around, were you and him driving around the car?
Hours. Because I mad at him, he was so angry, not going home, take him home when I want to. He just riding until I had to make up a lie to say I'm gonna come back for him to drop me off.
So where did the car eventually stop? Did it stop back at his mother's house?
He eventually took me home. And that's it. My grandma just convinced like where your hair at, because I just got my hair done. Okay, let's do it. We hit me. Shirt bloody.
So we're talking about December 28th. Was that night he brought you home?
No, it was the next day. He wanted me to stay. Just somebody faced me up. He didn't want me to leave.
So after driving around for a few hours.
I was still with him prior.
And you did return to his brother's house?
Yes.
Did you spend the night there?
I was scared. Yes, I did.
And then he dropped you off at your grandmother's the next day.
He just threatened me. The way he do me, my family. Like all this crazy stuff.
Do you remember around what time the next day, December 29th, he dropped you off at your grandmother's?
I don't remember what time, but it was early.
In the morning?
Yes.
Now, you said that the first moment you saw the gun was inside his brother's house that day. But prior to that, had you ever thought that Mr. Brownlee had a gun?
So we have to have Dr.
The relevance is, but fleshing out the story about this gun, which is the source of 4 of the charges here. Just want to. There seems to be some discrepancy about where this gun came from.
What's your question again?
If you'd ever known of Mr. Brownlee having a gun prior to this incident.
Fair question.
You said, have I?
Did you ever know of Mr.
No,
Brownlee
I
having a gun prior to this incident? Did you ever know of Mr. Brownlee's brother having a gun?
No.
You've never seen a gun in the house.
No.
You've never seen Mr. Brownlee with a gun.
Okay, yes.
Prior to this,
Yes.
you see him carrying a gun
In the house, yes.
in the house
Yes.
on a different
He had
day.
it tucked in somewhere in the car. He won't have it like on, he will have it with.
So are you saying that you've seen him with a gun in the house or in the car?
In the house.
In the house. On his person. On a day before December 20th. Was that one time?
Yes.
Do you remember about when that was? One month. So you said that we're in the house on the 28th. He hit you with the gun. You went into the car, you believed he still had the gun, but you did not see the gun in the car. Did you ever see the gun again after that? Now, you went back to your grandmother's house the next day. As far as you know, did anyone in your family attempt to contact Mr. Brownlee?
And no, they did. He called me. Nobody called me to pay it off. As if he didn't do it. My grandma trying to hear that. That was a big fist that hit me in my face.
So as far as you know, no one in your family contacted him, but he contacted you the next day.
Yes.
Now, so you went to the police precinct on the 29th. Mr. Brownlee was not arrested that day, was he?
They called. They said they were going to pick him up. And they called the next day. They picked the Sean Brownlee up.
The next day?
Yeah.
Would it be accurate to say that Mr. Brownlee was arrested about a week later on January 6th?
Yeah.
Did you have any contact? Was there any contact between you and Mr. Brownlee, between you going to the police station and him being arrested on January 6th? No contact.
No.
Did you ever seek medical attention?
No.
No, you never went to the doctor.
Oh, yes, yes. For, my water was just busted it.
Where did you go?
In for hospital.
To Henry Ford Hospital.
Yes, to make sure I don't have no concussions, and brain damage.
And do you remember about when that happened? Was it the same day you
It's
went
like
to
they
the
told
police?
me, the police told me to go the same day.
December 29th.
Yes.
And do you know that Mr. Brownlee was on parole at the time?
Yes.
I have no further questions. Can you redirect?
No, Judge.
Thank you. You may step down. Sure. Want to see? Looks like Mr. Shine tapped his face. Any other witnesses for the people?
No, Judge.
Any witnesses for the defense?
None, Your Honor.
Your Honor, the people request, to have counts 1 through, 4, which are the felony counts, to be bound over, and then count 5, the domestic violence, would carry over as a misdemeanor. We believe that the testimony given by the complainant established the elements required for the fact that, the defendant, Mr. Sean, Brownlee, did assault her with a weapon. That weapon being a handgun, or I think she described it as a pistol, and that he was a felon at the time of possessing that handgun, and therefore was ineligible to do so. And then counts 3 and 4, the felony firearms, would both attach to count 1 and count 2. We believe that the testimony was credible, and it's very clear that the complainant is still extremely fearful and terrified of the defendant and testifying today. And therefore, we do request that all the counts be found over to the circuit court based on the probable cause statement.
Your Honor, today we would object without.
Court, after hearing the testimony of the claimant witnesses, Ramsey is satisfied people met their burden of probable cause as it relates to the charges contained in the complaint warrant. The court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this has been committed. Defendant will be bound over to Wayne County Third Circuit Court Criminal Division for the proceedings. His arraignment on information date and time will be March 6, 2023 at 9:00 a.m.
Next.
I don't see how that judge can tell you that one. Oh, shit, wow. Yeah, they can't tell she was lying on that stand, man.
What's up, bro?
That's the attorney who called. He said something about tomorrow.
Mr. Gregory, how can I help you, sir?
Hello, Your Honor. I have a preliminary schedule for tomorrow for Malik Southall. And I at the PCC, I did worry that this was going to happen. The trial that I'm in now is not going to conclude before tomorrow. So I'm asking that tomorrow's preliminary be adjourned.
Did you tell me that at the time that we were setting the exam date?
I did, Your Honor.
What did I say?
You said, well, we only have the 28th. And so you wanted to set it for the 28th.
What's your client's name?
Malik Southall.
Yes, case number.
Have a case number? Wait, whoever is it.
I know the case number.
What's the case number, sir?
I'm looking for it right now, Your Honor.
Ms. Phelps, you ready on Harrison?
Well, I am judge, however, my client is not.
Where's your client?
I don't have any information.
Okay. Calling case 2355472, people of the state of Michigan versus J.T. Lanier Harrison. Defendant is charged in count 1 assault with intent to do great bodily harm, less than murder or by strangulation. Count 2 assault with a dangerous weapon. Count 3 domestic violence. The defendant has a habitual report of incidents. Appearances for the record.
Good morning, or I guess good afternoon, Your Honor. Someone will speak on behalf of the people, P83923.
Good afternoon, Your Honor, neighborhood defender service by Alan Phelps, P8335, period, behalf of the years.
So where is the defendant, Ms. Phelps?
Your Honor, I don't have any information about his whereabouts.
Court will issue a case, revoke bond, accept a new bond, and 25,000 cash. After I gave him a personal bond, how about that?
Your Honor, he did call me last week about, power outage, potentially not having his phone charged for today, but I don't have any additional.
Okay, let's take the lunch till 1:45.
Your Honor,
Yes, sir.
did you, I put the case number in the chat. I didn't know if I needed to say it out loud for you as well.
It's 23055-279. Did you contact the prosecutor, sir?
I have talked to him. He's given me permission to sign my name on any orders if needed, Your Honor. Or stipulation of orders.
Who was the prosecutor?
Mike Kleinfeld.
It's set for exam tomorrow.
That's correct, Your Honor.
I think this is my only case I had set to. Calling case 23055-279, people of the state of Michigan versus Malik Tehran Southall. Defendant was charged in count 1 second degree murder, count 2 assault with intent to murder, count 3 felony firearm, and count 4 felony firearm. Your appearance for the record, please.
Austin Gregory, PA 5193 on behalf of Mr. Southall.
So, Mr. Gregory, I think I do remember you telling me that there was a possibility we may still be in trial. Now, I played the heavy hand on you, and I made you set this date. So you told me so. Problem is, I set another date, but I need the prosecuting attorney here as well.
You're right. Well, he has given me permission. So if the court has another date in mind, he's given me permission to sign on any stipulated motion or order to sign his name to adjourn.
How can I set a date if he's not here though? What if he has a conflict?
That's true, Your Honor. I can try to give him a call and see if he can hop on.
Okay.
All right. Thank you, Your Honor. Should I try to?
Fine, if you like.
What did you say, Your Honor?
Come back at 1:45 if you like. We're about to take lunch.
Understood, Your Honor. Thank you.
All right, thank you, sir. Appreciate it. Sorry about that.
No problem. Bye.
Everybody go eat. So Oh, good. Oh, 45. See y'all back at 145? Yes, sir. It's hot in here.
It is. I have my. Go ahead, sweater back here.
No, right.
I knew better. To be honest.
Yeah.
Yeah, I'm gonna take these down. Yeah, but you're talking about.
The Carolina.
Listen, okay? I'm like, ooh. Me, it is coming down like ice.
It's just raining, no noise.
It was some ice. but-
Oh, really?
That's if you think it wasn't raining, not that icy stuff we had last week.
No, it was a little ice coming down.
Oh, man.
Did you say you want to use some regular water? Yeah, give me some water, please. Thank
I remember this in the school. Good and bad, thank God mostly good.
you. Okay, good.
Yeah, it's so darn hot here.
Mm-hmm. That's why
Well, it's cold outside.
we nicknamed it the oven.
Thank you.
I know about that, though.
Yeah. Just get some water.
That's sure.
I'm gonna lock it back for you.
No, I'm here now, you leave it open.
No, leave it, okay.
Somebody about to get jacked up in here.
Pardon? What did you say, the heat?
Oh, yeah, I'm saying, when I left, I know I locked that door, and when I come in, it's still locked, but it's propped open. So I'm like, okay, I know I ain't crazy, because I know I locked that door.
And who was that person that I needed to admit for again?
Oh, that would be. Brownlee. Deshaun.
Oh, okay. Okay. Oh, they gonna come back.
Got one more I gotta call up, it's the Malik Davis, which I hope that don't go.
Oh, that's the 2 o'clock.
Hey, I'm home.
Hey. Is it a bathroom? Yeah. It is. Oh. Hmm.
So they don't need to hold it, right?
How you doing there, Mr. Kleinfeld?
Doing all right. How are you?
Oh, good. Okay, Mr. Gregory is back.
You see, okay?
Oh.
You hear that static from me? You hear that static over there?
I don't hear it started.
Static
Yeah.
right above me.
I hear it.
There might be some water. Because it's leaking on the first floor.
What is it? You have that issue.
Yep.
All right, so we are ready for softball. Ready, guys?
Hi, Judge.
Hey, how you doing? Recalling 23055279001. People of the state of Michigan versus Malik Tehran Southall. Defendant is charged in count 1, homicide, murder, second degree. Count 2, assault with intent to murder. Count 3, felony firearm. Count 4, felony firearm. Matter scheduled for preliminary examination on February 28th, tomorrow. Appearances for the record, please.
Good afternoon. Mike Kleinfeld for the people, P79328.
Good afternoon, Your Honor. Austin Gregory, PA 5193, on behalf of Mr. Southall.
Okay, so Mr. Gregory is here to tell me that I told you so. He's still in trial.
Your Honor, I wasn't going to use those words.
He needs to reschedule the preliminary examination to schedule for tomorrow. I tried to make it though. Well.
That's correct. I am scheduled for trial tomorrow.
How many witnesses do you have, Mr. Kleinfeld?
5, but I think really we could do it with 3.
I can do it as early as March. No, I can't. I'm sorry. How about March 14th at 1:30?
If we know that we're going to be done in a single day, then that works, Your Honor.
Oh, yeah.
Yeah, that would be fine.
All right, so I'll adjourn this matter to March 14th at 1:30. Bond will be continued.
Thank you.
Thank you.
Oh, hey, how you doing? Appreciate you reaching out. All right. Okay. Jeremiah Johnson. Calling case 2355439 for the state of Michigan versus Jeremiah Johnson. Defendant is charged in count one assault with intent to do great bodily harm, less than murder or by strangulation. Count two domestic violence. Appearances for the record.
Good afternoon, Your Honor. Someone 16 on behalf of the people, P83923.
Good afternoon, Your Honor. Nancy Castro from Neighborhood Defender Service of Detroit, appearing on behalf of Mr. Johnson, P number 80549.
Tell me your name, sir. There's a date and time set for preliminary examination. Are you ready to proceed?
Judge, the people are not ready to proceed at this time. I was able to get in touch with the complainant, Sherelle Stevenson. I spoke with her. She indicated that she was not present today despite knowing the date and time, and therefore we are unable to proceed without her.
Your Honor, defense makes the motion to dismiss.
So ordered. The court will dismiss this matter without prejudice. Thank you.
Your Honor, Mr. Johnson is on a tether. Is it possible to put on
The
his?
dismissal order should take care of that.
Thank you very much.
We just like to have the lead dates.
Thank you, sir.
Perfect.
All right. Yeah, Brown, you got
You hear?
No, Mr. Basant yet?
Mr. Bassan is here, Your Honor.
I'll have him step in.
Well, okay.
Good morning. Good afternoon.
Open that door and have a seat.
Calling case 2355513, people of the state of Michigan versus Malik Davis. Defendant is charged with count 1, unlawful imprisonment, count 2, assault with intent to do great bodily harm, less than murder or by strangulation, count 3, domestic violence. Appearances for the record.
Good afternoon, Your Honor. So I'm speaking on behalf of the people, P83923.
And good afternoon, Your Honor. Attorney Kevin Basant, P71061, on behalf of Mr. Malik Davis, who's present in court.
Tell me your name, Mr. Davis.
Malik Davis.
He also has case 2355512, charged in count 1, assault with intent to do great bodily harm, less than murder or by strangulation, count 2, domestic violence. Are we ready to proceed to exam?
Judge, I believe this is at 2. I don't know if any of my complainants are present. I would like to just make note, I'm actually reaching out to the other APA. This was one of the ones, again, I think it was maybe set within the last week and a half. And so, based on my notes, I don't know whether or not the complainants were ever even notified of this because of that. Unfortunately, because of Ms. or APA Drain's actions, we've had several prosecutors kind of taking over. And I think it's created a bit of miscommunication in regards to when cases are set and then, of course, subpoenaing those witnesses. I'm just waiting to hear back, but I don't even know if at this point they would have been aware to have appeared today. There's no indication in any of my notes for either file that there has been contact made with the complainants.
Just briefly on behalf of Mr. Davis, the defense counsel prepared to proceed. This matter has been set for a preliminary exam. I believe it's been more than sufficient time to notify the witness, regardless of the prosecutor's, vacation or scheduling issue. Today is the day and time we're ready to proceed. The complainant is not here, we're ready to proceed. Mr. Davis has been in custody from day 1.
In order for this court to find or to adjourn this matter, the court would have to find good cause. Not sure that the negligence of the prosecutor's office qualifies as good cause. Could, however, grant people's request for an adjournment and also grant the defendant a reasonable bond, a more reasonable bond he can make, given that he's here for exam, he's been in custody the entire period of time. And this matter would be as a result of the people's negligence and not being ready for the exam. And then that way, we don't have to start this process all over again, the defendant being arrested, having to first file and go through all that again. So I can grant the adjournment and give the defendant a bond. Planning on both.
That's correct, Judge. If I may, Judge, for the record, I would move for dismissal, but I'm prepared to make a lot of arguments as well.
That motion will be denied. The court will grant the adjournment. Esteban,
Mr. Bond, Judge, Mr. Davis has absolutely no criminal history whatsoever. This is his very first contact with the law. This is a situation where obviously, this is a girlfriend / child's mother that he has in common. There would be absolutely no contact whatsoever with this particular complainant if he's able to post bond.
how do you say this is his first brush with the law and he has 2 cases?
Well, what I mean by that, Judge, is that he's had no priors. So when this case was first, he was first charged with these 2 cases, this was his first ever criminal contact. He has no history whatsoever, other than these allegations. And Judge, I understand that they are charges, but at the same time, Judge, my position that these are allegations, which we were prepared to contest today at this preliminary exam, regardless of the situation with the prosecutor or the complainant. Moving forward, Judge, he would have absolutely no contact with the complainant. He lives separately from the complainant. They do not live together. They do have a child in common, but family court is handling that situation. My client is gainfully employed. He was working at the time of this incident, actually having 2 jobs. And so for those reasons, Judge, I do believe a $500,000 bond is unreasonable given the circumstances, and I understand the allegations. But with that being said, Judge, I would ask for a significant bond reduction to hopefully allow him to post bond, to continue fighting this particular case, Judge, and to get back to work. But he's been in custody from day 1 with no issue.
How much could you post to get out, sir?
$1,000
You said 1,000?
Yeah, 1,000 to my savings that I have.
All right. And the court will reduce the bond to $500 cash surety on each case.
Thank you very much, Your Honor.
Now we need a new date. And no contact with the complaining witness. You understand what I mean by no contact? I don't even want you to breathe in her direction. Got it?
Sure.
If I find out that you do, I'm gonna put you in, I'm gonna keep you there as long as I possibly can. Understood?
Yes, sir, I understand.
We can do March 13th at 9:30.
I technically started trial in Frank Murphy that morning. I don't think it's going to go, but I am scheduled for trial before Judge Marco. And that's supposed to be technically a 3-day trial, the 13th of this.
March 17th at 10 o'clock.
That's actually perfect for me.
March 17th at 10 o'clock it is.
Thank you, Judge, I appreciate that.
I need a bond reduction, Mr. Bassan.
I will fill that out now, Judge.
Judge, that was 10 a.m., is that correct?
That's correct.
Okay, thank you.
I started filling out those 2 already. I filled out the 2 already.
Yeah. Thank you.
No, I just did it. Okay.
Okay. I know.
Yeah.
I'm gonna sit here, so I can.
Thank you.
All right, thank you.
I'm gonna need you to sign it. I know you run out of here.
Thank you very much, Judge. You want to take care.
Thank you, you too.
Thank you.
His lawyer meet him downstairs?
Hmm?
Is his lawyer meeting him downstairs?
This lawyer came? Yeah.
I know he's seeing his lawyer want to speak to him. That's what I
Oh,
know.
no, no, he said that he would meet him downstairs.
Okay.
Yeah.
You all right?
That concludes the docket for the day, folks.
So Your Honor, Ms. Hollins, the one that we, that you said that you wanted to release her to a inpatient facility,
Yes.
is that without a tether?
Yeah, because I think if she's gonna have an MRI, she can't have a tether attached.
Okay.
So this is Johnny Lee Young. Justice Attorney Khalil. Prosecutor Young,
Actually, she's in the office.
can you have her step in for a moment?
Sure.
I was looking at the file on that Johnny Young case. Looks like it was set for exam today, at least according to the file. Is that what you did?
It was, yes, Judge. But that was the one where in the morning, his attorney appeared on the scene because she had reached out to both myself and, I believe it was the court clerk indicating that it was gonna be an adjournment because she had outstanding recovery that we were trying to get.
So we adjourned to March 10th at 9:45, is that right?
I don't have it in front of me, but.
March 10th.
Yeah, okay.
Okay.
And that would be the exam date, correct?
Thank you so much. I
Yes,
just
of
wanted to
course.
clear that up, make sure I was on the same page.
Yes, thank you.
See. Hey, you all have a good day.
Thank you as well.
How's it going, Judge?
Thank you, sir. You as well.